Please note that Deputy McLaughlin is substituting for Deputy Carty and Deputy Doherty is substituting for Deputy Brown for today's meeting. This meeting is now in public session. Before we begin, can I remind members, witnesses and persons in the public gallery to turn off their mobile phones. The purpose of today's meeting is to examine the weighing of fishery products. The committee will hear from representatives of the Sea-Fisheries Protection Authority. From the 28th of February, the legal requirements for mask wearing in all settings have been removed. However, it is still good practice to continue to use face masks coverings, particularly in crowded areas. The service encouraged all members of the parliamentary community to wear face masks when moving around the campus or in close proximity to others. Before we begin, I want to bring to your attention witnesses giving evidence within the parliamentary precincts are protected by absolute privilege in respect to the evidence to give to a committee. This means that witnesses have full defence in any defamation action for anything said at a committee meeting. However, witnesses are expected not to abuse this privilege and may be directed to cease giving evidence on an issue at the Chair's direction. Witnesses should follow the direction of the Chair in this regard and are reminded of long-standing parliamentary practice to the effect that, as is reasonable, no adverse commentary should be made as against an identifiable third person or entity. Witnesses who are to give evidence from a location outside the parliamentary precincts are asked to note that they may not benefit from the same level of immunity from legal proceedings as a witness giving evidence within the parliamentary precincts and may consider appropriate to take legal advice on this matter. Privilege against defamation does not apply to publication by you outside the proceedings held by the committee of any matters arising from the proceedings. Members are reminded of the long-standing parliamentary practice to the effect that members should not comment on, criticise or make charges against either a person outside the House or an official either by name on such ways to make him or her identifiable. Parliamentary privilege is considered to apply to the utterances of members participating online in a committee meeting when the participation is from within the parliamentary precincts. There can be no assurances in relation to participation online from outside the parliamentary precincts, and members should be mindful of this when they are contributing. The committee will hear from representatives of the Sea-Fisheries Protection Authority as follows: Mr. Pascal Hayes, Executive Chairperson; Ms. Olive Loughnane, Senior Executive Manager and Director of Transformation; and Dr. Micheál O'Mahony, Senior Executive Manager and Chief Scientific Advisor. I'd like to welcome the witnesses to the meeting, and I will call on the witnesses to make their opening statement.
Good evening, Chairman and committee members. We thank the committee for the invitation to appear today. We welcome interest in the Sea-Fisheries Protection Authority, our work as the regulator for sea fisheries and seafood sectors, and to have the opportunity to outline how we seek to ensure effective and fair regulation of the areas under the authority's mandate in order to support safe, authentic and sustainable seafood. I'm joined today by my colleagues Dr. Micheál O'Mahony, who's a Senior Executive Manager and our Chief Scientific Advisor, and Ms. Olive Loughnane, who's a Senior Executive Manager and our Director of Transformation. By way of introduction, Ireland's seafood economy was worth an estimated $1.26 billion in 2021, having experienced a growth in GDP of 15.3% when compared to 2020, with Irish people consuming an average of 25 kilos of seafood per year. The sector supports over 16,000 livelihoods, predominantly in coastal communities along the Atlantic Ocean, Celtic Sea and Irish Sea. Effective regulation and oversight of the sea fisheries and seafood sector is essential to the achievement of our shared ambitions for the development of Ireland's seafood sector, as well as ensuring that Ireland's shared marine resources are sustainable for future generations of fishermen and fisherwomen, coastal communities and the Irish and international consumers. The SFPA plays a key role in promoting compliance, verifying it and, where necessary, using the powers provided under legislation to enforce sea fisheries and seafood safety laws for all areas under our remit. This includes all fishing vessels operating within Ireland's 200-mile limit, almost 2,000 Irish registered fishing vessels, wherever they operate, and all seafood produced in Ireland's seafood processing companies. We acknowledge that the focus of today's meeting is on the weighing of fishery products. However, fishery control is one of a number of functions performed by the SFPA. The SFPA's scope of work is broad and varied. It includes ensuring legal and sustainable sea fishing. In food safety, it includes approving, registering, auditing and inspecting fish processing establishments, along with classification and monitoring of bivalve mollusk production areas. In food trade, it involves certification of Irish seafood exports and verification of imports. In data matters, the SFPA collates the state's formal record of fishing activity. The SFPA employs staff in the major fishing ports around the coast and at our headquarters in Clonakilty, each of whom is committed to the mission of the SFPA and ensuring sustainable fish stocks for future generations of Irish fishers. Their work to fulfil their duties as set out under Irish law can often be undertaken in challenging circumstances. This is particularly the case for our staff based in the Killybegs Port Office in recent months. We are proud of the work undertaken by each and every one of these SFPA employees. Under Irish legislation, the legal onus is on the fishing industry to comply with national and EU sea fisheries and seafood safety regulations. The SFPA's systems are designed to provide regulatory oversight with checks in place throughout the catching, storage, transport and processing stages. Similar to our counterparts in other EU countries, the SFPA operates a risk-based control policy to maximise its effort in those areas of greatest risk of non-compliance or abuse. There are in the region of 20,000 landings of pelagic and demersal fish by larger vessels in Ireland on an annual basis. The SFPA does not have the resources to be on every fishing deck, at every haul, nor every landing of every vessel, necessitating our risk-based control policy. Pelagic fish is a term referring to shoaling migratory oily fish which swim in the middle of the water column, including mackerel, horse mackerel, herring and blue whiting. Pelagic fish are stored on board fishing vessels in bulk tanks and pumped ashore in bulk quantities. Demersal fish refers to bottom-dwelling whitefish with a habitat on the continental shelf seabed, such as cod, hake, whiting or monkfish. Demersal fish are typically sorted by species and gutted, then iced and boxed on board. Of the 20,000 landings annually by larger vessels, an estimated 600 are bulk pelagic landings. That's roughly 3% of the total annual Irish landings. Bulk pelagic fishing is highly industrialised, pursued by some of the largest vessels in Europe. Bulk pelagic landings are large in terms of both quantity of fish and monetary value and can frequently exceed €1 million for a single landing. Pelagic landings involve commercial processes whose speed and automation adds to both control challenges and compliance risks. Controlled supervised weighing of a small proportion of pelagic landings is only one part of SFPA controls for pelagic fisheries and landings. At sea data monitoring, pre-landing checks and post-transport weighing controls in permitted plants are also used. Records of these houses in 2005 and 2006 will show that amongst the central reasons for the Irish Oireachtas to establish the Sea-Fisheries Protection Authority through the 2006 Sea-Fisheries and Maritime Jurisdiction Act were allegations of significant non-compliance in pelagic landings and the need for meaningful controls. In this submission and in our contribution to this committee, we hope to emphasise the following points. SFPA implements and regulates as provided by the Oireachtas and as required under Irish law. Fish weighing obligations exist for operators for the express purpose of ensuring that the amount of fish landed is accurately assessed and to ensure sustainable fishing stocks for future generations. The SFPA does not catch, land, weigh, nor declare fish. The accurate weighing of fish is the legal responsibility of the operators and not the SFPA. Of the approximate 600 landings of bulk pelagic fish on an annual basis, 19 out of every 20 landings currently avail of a derogation in the interim fisheries control plan to weigh after transport at a processing facility. 1 out of every 20 bulk pelagic landings are subject to a supervised weighing on landing. Specific control focus on a small proportion of bulk pelagic landings is an explicit control requirement to manage the particular risk of such landings and a significant part of what secures the overall derogation to enable post-transport weighing of all landings to Ireland. In the absence of an interim control plan that enables the weighing after transport, every landing into Ireland would be required to be weighed upon landing. One of the requirements of EU legislation, which the SFPA is bound to enforce by the Oireachtas, is an obligation on operators to weigh wild-caught fish on landing. That EU legislation, as agreed by Ireland, has a default starting point of all such fish being weighed immediately at landing, with no delegated authority to the SFPA to diverge from that. For clarity, the default position under EU and Irish legislation is that all landings into Ireland should be weighed upon landing. The potential for fish to be transported from the point of landing before weighing is set out as one of two potential derogations of Article 61 of Regulation EC number 1224 of 2009. In both cases, derogations can only be implemented if approved by the EU Commission. In 2012, the SFPA secured EU Commission approval for a control plan under Article 61(1) of 1224 of 2009 to facilitate the derogation for weighing in Ireland after transport from a place of landing in Ireland. Such weighing could only occur in plants specifically permitted for that purpose. The SFPA had a variety of different controls in place to manage compliance risks arising from this post-transport weighing regimen. In the case of bulk pelagic weighing, there was an overt reliance on operators' weigh belt systems, with the SFPA control input both at landing and at post-transport weighing. Subsequent to the introduction of the 2012 control plan, SFPA controls identified significant and ongoing non-compliance risks in post-transport weighing of bulk pelagic fish. Several instances of weigh unit manipulation resulted in temporary revocation of permits until necessary enhancements were made, including one subsequent conviction. In no case of manipulation was there any particular deviation between the declarations of masters, of purchasers or weighers. I think that's worth repeating, Chairman. In no case of manipulation was there any particular deviation between the declarations of masters, purchasers or weighers. The SFPA responded to increased understanding of non-compliance risk by enhancing its control focus on landings and weighing and strengthening the permit conditions to include, for example, CCTV feed to SFPA. Nevertheless, a clear sentiment existed of ready manipulability of such systems, with any such manipulation resulting in inaccurate declarations of the amount of fish landed and potentially fraudulent food marketing. This puts at risk the reputation of Ireland's entire sea fisheries and seafood processing sector, as well as the sustainability of Irish fishing stocks for future generations and the authenticity of Irish seafood consumed domestically and across the globe. In 2014 and again in 2018, the Director General of Maritime Affairs and Fisheries of the European Commission conducted an audit of bulk pelagic control in Ireland. The 2018 audit formed the view that the risk of non-compliance by bulk pelagic operators with their weighing obligations was unacceptably high. That report also highlighted deficiencies in the control methods being implemented by the SFPA, finding that these were not sufficiently robust to ensure operators did not under-declare their catches. A subsequent administrative inquiry by the Commission was used to quantify the extent of the concerns. The SFPA worked to address the various concerns through enhanced controls. A particular focus by DG Mare was the perspective that, as part of the overall control regimen allowing most landings to be weighed after transport, there must be some instances of control authority instigated pre-transport weighing. The SFPA incorporated such events into its pelagic controls from 2020 under the previous control plan. In response, industry used a pier-side device that would actively dewater, then weigh those dewatered fish before reuniting the fish with their original water. Irish courts found no reason in law to prevent the SFPA from approving such a device for weighing, and it was used for weighing pelagic landings during 2021. In April 2021, DG Mare revoked the Irish Control Plan as a result of significant and ongoing concerns regarding inaccurate weighing of catches, particularly by operators landing bulk pelagic catches to Ireland. Accordingly, all landings to Ireland which previously would have been weighed at an Irish establishment in accordance with the plan were then legally required to be weighed at landing. At a hearing with this Oireachtas committee on the 11th of May 2001, members were clear in relaying and endorsing concerns voiced throughout the industry about the impracticality of this. In the case of demersal fish landed in standardised boxes, the Irish sampling plan remained in place to reduce the impact. Then in September 2021, a control plan for pelagic and demersal catches was submitted by the SFPA, followed by ongoing dialogue with DG Mare. During this dialogue, it became clear that the EU Commission approval would only be achieved with the inclusion of pre-transport control supervised weighing performed on a non-industry owned, non-industry operated device such as a weighbridge. The SFPA accepted such a control plan on an interim basis from January to April 2022 in the interest of facilitating post-transport weighing. Under this interim control plan, the SFPA had multiple obligations, including the assessment of processors' plants' compliance with weighing conditions as set out in the interim control plan, and issuing of permits to allow the invoking of the provisions of the plan to apply. In simple terms, the SFPA had to develop the control infrastructure, reversing the paradigm shift that had occurred in April 2021 towards pierside landing, to then, in January 2022, develop controls on post-transport weighing. As the very premise of a 61-1 regimen under a control plan is one of overt reliance on the vast majority of fish being weighed after transport, the SFPA controls needed to shift back to weighing upon landing pierside. Additionally, the interim control plan had explicit obligations for pre-transport controls as part of an overall control of post-transport weighing. One of the explicit stipulations which arose from dialogue with the EU Commission was that pre-transport controlled supervised weighing should take place for bulk pelagic landings on non-industry owned, non-industry operated weighing systems. Key representatives of the Irish pelagic industry were informed of the inclusion of this new stipulation in late 2021. The expected frequency of control weighing upon landing was linked to Regulation number 404 of 2011, Article 107, meaning that 5% of bulk pelagic landings, or 7.5% of the fish quantity, would be subject to controlled supervised weighing. Under this regimen, therefore, 19 out of every 20 landings could be weighed after transport at a permitted facility. 19 out of every 20 landings could be weighed after transport at a permitted facility. During the period from the opening of the season in February until the beginning of March, the SFPA accepted weighing on an industry-owned pierside device. It subsequently became clear that the use of this industry-owned pierside device did not fulfil the requirements of the interim control plan, which stipulated that weighing must be conducted on a device under non-industry ownership. It is clear that operation of the interim control plan, without fully insisting on the strict terms as set out in the EU-approved control plan, is regrettable and detracted from the overall implementation. At this stage, we are of the view that the significant amount of work done by the SFPA in early 2022 to implement the interim control plan should have moved more quickly to implement this stipulation. From early March 2021, the SFPA moved to ensure the controlled supervising pre-transport weighing events met all of the terms of the interim control plan for those approximately 5% of bulk pelagic landings. In the absence of an alternative, this meant weighing of bulk tankers of fish with transport water on a state-owned weighbridge. To meet the requirements of the interim control plan, operators may select one of two options for conducting weighing before transport at Killybegs Harbour. Option 1, in this method, the fish exiting the vessel are discharged into an industry-owned pierside system, which momentarily separates the fish from the water. The fish is immediately placed directly into a tanker that has been pre-filled with water and pre-weighed. The tanker containing the fish and the water is then reweighed on the SFPA approved weighbridge, and an accurate weight for the fish is obtained. In option 2, in this method, the fish and water exiting the vessel are discharged directly into a pre-weighed empty tanker. The tanker containing the fish and the water is then reweighed on the SFPA approved weighbridge. The fish remain with their original water, which operators seek to minimise in order to balance quality considerations with fish weight accuracy concerns. In both options, the pre-transport weight, that is, the weight on the weighbridge, must be used in all statutory declarations, including landing declaration by master, sales note by purchaser, and transport document of transporter. In neither option is there any requirement for the fish to be dried before, during, or after controlled supervised weighing. It is with genuine concern that the SFPA became aware of a sustained campaign of disinformation and misinformation, suggesting the SFPA was not adhering to provisions of the Northern Ireland Protocol following the UK departure from the EU. The SFPA confirms that there has been no change in the fish weighing on landing arrangements between the Republic of Ireland and other jurisdictions as a result of Brexit. Under the EU regulations, which SFPA is bound to implement by this Oireachtas, landings to Northern Ireland could never have been weighed in Killybegs under the terms of an Irish control plan. That derogation is only applicable to post-transport weighing of fishery products when weighed within the member state of landing. The only way in which fishery products might be weighed in Killybegs following a landing to Northern Ireland would be through a common control programme between the UK and Ireland approved by the EU Commission. It is important to reiterate no such common control programme has ever existed, either before or after Brexit. Therefore, landings to Northern Ireland are treated similarly to landings in any EU state with which Ireland does not have a common control programme. Irish operators may choose to purchase fish landed to a jurisdiction with which Ireland does not share an approved common control programme, such as Northern Ireland. In such cases, the weighing must have taken place in the landing jurisdiction, either through the default of immediately at landing or perhaps at a permitted post-transport establishment in that landing territory if a control plan exists there. Crucially, however, the weight of the fish upon landing in another jurisdiction must be the weight declared by all parties. Declaration of a weight after transport at a processing facility in the jurisdiction of Ireland is not permitted. Permitting establishments to weigh after transport at a processing facility following a landing in the Republic of Ireland is a significant exemption available under the Interim Fisheries Control Plan to operators who have the systems to apply such a permit appropriately. The SFPA will not accept the misuse of the weigh after transport system, which has the potential to jeopardise the EU Commission approved exemption for the entire fishery and seafood processing sector. If this exemption is revoked, all landings of pelagic and demersal fish across Ireland could be required to be weighed pierside. The interim control plan agreed in December 2021 had a prescribed applicability from the 1st of January 2022 until the 30th of April 2022. On foot of a DG Maori proposal in March 2022, SFPA applied for an extension of approval of the interim control plan until the 31st of December 2022. It is a positive development that this was approved by the Commission in late April, and the control plan was adopted by the SFPA to extend previously issued weigh permits for several months. The SFPA anticipate further dialogue with the Commission with a view to the Irish control plan on a permanent footing by the end of 2022. In closing, Chairman, we would like to emphasise again that the role of the SFPA is to regulate the sea fisheries and seafood sectors to both ensure compliance with Irish and EU laws and so that we can ensure sustainable fishing stocks for future generations. We encourage committee members to see the broader merit of the work being undertaken by the SFPA to ensure fish are weighed completely and accurately with overall minimal impact on quality. In the absence of approval from the European Commission of an interim or full fisheries control plan, there is no exemption to weigh fish after transport at an approved facility, and so all landings, pelagic and demersal, would be subjected to weighing upon landing. As the industry and this committee experienced last year, the ramifications of no control plan are experienced right across the seafood sector and in coastal communities around Ireland. Control is what the SFPA provides. Declaring less fish than are actually caught is a real and ongoing risk that threatens the sustainability of fishing stocks for future generations and the authenticity of Irish seafood. Compliance with the regulations is with the industry. They have a legal onus to comply. Our role is to oversee compliance. For those involved in bulk pelagic fishing, the control plan enables 19 out of every 20 landings to be weighed after transport. The controlled supervised weighing of 1 out of every 20 landings of bulk pelagic fish should be viewed in the context of the very real alternative of 100% of landings needing to be weighed at the pier. We ask committee members to consider carefully the array of potential motivations of operators choosing to decry the need to weigh 1 out of every 20 landings outside of system.
Can I just get a point of clarification? This is very important. That's a very serious statement just been made there.
To question.
You need to clarify that sentence you just read out. What do you mean by that sentence?
Deputy, no, he's making his opening statement.
With respect, Chair, you can't impugn the reputation of people outside the House in this committee. I'd ask them to clarify that sentence.
Just the opening statement has gone on a half. No disrespect, but in all fairness, 5 minutes is enough for an opening statement.
Serious
and give us all opportunities to ask questions.
It's a very serious statement, Chair.
I accept fully the opening statement has gone on and gone on very long, but I know there's huge interest in this subject, so that's why I haven't censored the length of it. But each member will get a quarter of an hour each.
But Chair, with respect, I'm asking you to deliberate here. That sentence, and if you don't mind, I'd like to read the sentence. We ask committee members to consider carefully the array of potential motivations of operators choosing to decry the need. What does that mean, the array of potential motivations? Is that questioning the motivation or the character of people outside this House? We need to clarify that. That's a serious matter, Chair.
Point of order. Chair, on a point of order, you read out at the start, it is not for any witness here to cast aspersions on people who can't defend themselves, and there is a limited number of operators, and that sentence is very, very serious and it should be withdrawn.
Ask that statement to be withdrawn.
The point has been made that you are making allegations against individuals, and it's clear in my opening statement and privilege that anyone at the committee meeting shouldn't do that. So do you want to withdraw that comment from your opening statement?
I didn't intend it in that way, Chair, but if it causes offence, I'm happy to withdraw that sentence.
That's not withdrawn. You know exactly what's been said there. You're an intelligent man, and I'm asking that it be withdrawn in respect to this committee.
Well, Deputy, I am agreeing to withdraw it.
Okay, that's good. Thank you.
Okay.
I have one more paragraph, Chair.
Okay, Mr. Hayes.
The SFPA's duty is to implement the laws passed by this House, encompassing both Irish and EU regulations. Committee members are no doubt aware that weighing provisions are amongst the considerations of a currently ongoing revision of the EU Fisheries Control Regulation. If new or amended laws and regulations pertaining to the sea fisheries and seafood sectors are passed by this Oireachtas, then the SFPA will implement these. Until then, we will discharge the duties set out for the organisation as set out by this House. Thank you, Chair.
Okay, thank you, Mr. Hayes, for which was a very lengthy opening statement. I'm now going to go to members to questioning. I'm going to give 15 minutes to each member. So, you needn't be obliged to use the 15 minutes if you want to be shorter. And I just want to put for the record that Deputy Pringle is substituting for Deputy Fitzmaurice. So, Deputy Collins, your first member to
Thank you, Chairman, and would like to welcome the witnesses. I'd also like to welcome Patrick Murphy here behind us in the Irish Southwest Fishermen's Association, and also Cormac Burke of the IFSA, and those two individuals have worked very hard to try and, I suppose, make fishermen's lives a little more easier in what is an extremely difficult time. And I hope that this will be the first of many meetings that we'll have with the SFPA going forward, and maybe the organisations that are out there, and ourselves as a committee, because there's a massive bridge there that needs to be built between both the man or the woman on the ground and the SFPA, and it's quite obvious to the whole country, or maybe the whole world out there. I'd wish to welcome you, Mr. Hayes, and your colleagues here today, and for us having the opportunity to ask some questions that we have of you, both in respect of your appointment, the policy changes that appear to be underway within the authority, ever since your appointment and your discharge of your duties in your new role as Chairman and sole Director of the critically important Sea-Fisheries Protection Authority, SFPA, in circumstances where the Sea-Fisheries and Maritime Jurisdiction Act of 2006 stipulates that there should be 3 such directors. I know many of my colleagues today would join with me in offering you congratulations on a personal level, while wishing you and the SFPA every success in discharging so critical a role in circumstances where the future sustainability of such an important resource as we have in the seas surrounding our small island nation must surely be achieved in conjunction with the ensuring the viability, sustainability and socio-economic health of our widely scattered, often remote and island-based coastal communities, whose people must, as those most intimately connected with the living resources of our seas, be entitled to derive the greatest economic benefit from this resource. Now, if you don't mind, obviously I've got 15 minutes and everybody else, and I have to respect my colleagues need to get in here. All my questions are simple yes and no. Some might require just a minute answer, and I might appreciate if we keep it there because I have a lot of questions. When a senior position is filled, could you, Mr. Hayes, you might explain to me, when a senior position is filled in the SFPA, the announcement is made by the Minister for Agriculture and Marine, as was in your case, Mr. Hayes. Is that the case, yes or no?
Yes, Deputy. So the appointments are made under the
right. No, yes or no, do fine. When the SFPA takes the owner,
Maritime Jurisdiction Act 2006, okay, that sets out the process for the appointment. Okay. The appointments are made by the Minister in accordance with that legislation.
Thank you. That's yes or no. Perfect. When the SFPA take the owner of a fishing vessel to court, the SFPA is represented by 2 senior civil servants. Am I right? Cecil Beamish and Josephine Kelly from the Department of Agriculture, Food and Marine. As this has been the case throughout the past 5 years, is this the case, yes or no?
No, Deputy.
Okay. And if it was the case, then how can the SFPA declare itself to be acting as a totally independent body?
But no is the answer to the first question, Deputy. The SFPA is independent in the performance of its duties. The 2 officials that you've named work for the Department of Agriculture, Food and the Marine and have no function in relation to the Sea-Fisheries Protection Authority. And
have they represented the Department of Agriculture, Food and Marine in any cases?
You'd have to ask them that Deputy. I don't know the answer. Well, hopefully. I do know that answer, actually, Deputy, because I know they have represented the Department, but not the SFPA, certainly.
Okay. You might please outline the official working relationship between the SFPA and the Department, DAFM.
So the official working relationship.
Yeah.
So the SFPA is an agency that's independent in the performance of its duties. Its role is set out by this House under the Sea-Fisheries Maritime and Jurisdiction Act 2006. Our funding comes through the Department of Agriculture, Food and Marine through that vote and is voted by this House through that department. The department has responsibility for corporate governance of the organisation, and outside of that, that's the only role that the department has. Sorry, I'm just checking with my colleague here to see if there's any other.
Yeah, so the state has set out a code of practice for the governance of state agencies. Deeper Department of Public Expenditure Reform has set that out. So there's an arrangement, the performance contract between the department and the SFPA set out under that code of practice for the corporate governance of state agencies.
Thank you. At the last SFPA appearance, and Dr. Susan Steele has moved to a different job, and wish her the best. Before the Joint Committee, Susan Steele claimed that there was a good working relationship between the SFPA and the industry and representatives, but this committee has been strongly advised that this is not the case. Out of the following representative groups, please inform us which one or more the SFPA has a good relationship with: the IFPEA, the IFPO, the IFSA, the ISWFPO, the ISEFPO, the KFO, the Islands FPO. I'm leading on to another question. Are any fisheries cooperative nationwide?
The topic today is...
Yeah, I'm on to that. That's my next...
Is the weighing of fish. And in fairness, to ask the chairman, has he a good work relationship with an organisation? That's not a fair question.
Well, yeah, but it's something that I think the SFPO have been continuously stating that they want to work with the organisations. I could be totally wrong here. Maybe they have a great relationship with every one of them, but we certainly need to know if they have one above another, because that's not what's been said out there.
No.
Okay. My next question, okay, throughout the Killybegs blue whiting controversy, the SFPA publicly insist that they continually offered the option to these vessels landing that they could indeed use the pelagic flow scales, but without actually saying that the SFPA were ordering that this state-of-the-art system declared suitable by the Irish High Courts as being fit for purpose, have the element of water removed from the system, and therefore that this option was just a different method of dewatering or dry landing the fish, thereby making them of no use for human consumption processing. Can you share your thoughts on this, please, Mr. Hayes?
Sure, Deputy. First of all, in relation to the pier-side weighing device, we've got to make a distinction here between the 19 landings out of 20 and the 1 landing out of 20. So the obligation is that we would supervise 1 landing out of 20 to enable the other 19 to be brought to the factories and weighed, or weighed on that pier-side weighing device, which is owned by the industry. So they have an option whether they want to weigh the 19 out of 20 in their factories or on that pier-side weighing device. In relation to the 1 in 20 that we need to supervise the weighing of, there's currently 2 options open to a master landing in Killybegs. One of them is that the fish is pumped from the vessel into the pier-side weighing machine and in turn placed into a tanker that has been pre-filled with water and pre-weighed on the weighbridge. Following the deposition of the fish in that pre-weighed tanker, it's brought back to the weighbridge and weighed again. 1 weight is subtracted from the other, and the result is the weight of fish in the tanker. The second option that's open to the master is or the operator, is to discharge into an empty tanker that has been pre-weighed. The fish are pumped into it with the water that they were originally in. It is up to the operator to take off as much water as they feel they can without interfering with the quality of the fish. They then go and weigh over the weighbridge, and that's recorded as the official weight of the fish.
Thank you. Thank you, Mr. Hayes. Under whose instruction are the SFP employing methods of monitoring and regulation that are not being used anywhere else in the EU? Are such decisions taken by yourself, Mr. Hayes, or by the SFP management, the board, or whoever they are? We'd appreciate, are the instructions handed down from above?
So, Deputy, as I said in my opening statement, the default position in relation to fish landing is that they're weighed at the point of landing. There is some unique aspects in relation to Ireland in the way that particularly bulk pelagic fish are landed, but I let my colleague Dr. O'Mahony deal with the general landing conditions, how it is in relation to the regulation and what the difference is in Ireland.
Sure, thank you. So the instructions are set out in the EU regulations. We're the regulator. We implement the regulations. The regulations come to us from the legislator, including the House of the Oireachtas, and we implement those regulations, Deputy. As Mr. Hayes has said, the default position, the starting point, the baseline of the regulations that fish are weighed immediately on landing. There are potential derogations whereby that weighing can take place after landing, but that authority is not delegated to SFPA or to any authority in any member state. It requires approval by the EU Commission.
Okay, thank you. Just looking here at a couple more questions. Mr. Hayes, what is your opinion on the introduction of the remote electronic monitoring and the deploying and use of remote cameras?
So, Deputy, this is a matter that's in the policy sphere at the moment. It is not contained in any regulation at the moment, and we don't, as a Sea-Fisheries Protection Authority, comment on matters of policy.
And would you please, give us your opinion on how this technology is not deemed sufficient for control purposes in a factory setting?
Sorry, could you repeat that, Deputy?
I said, would you please give us, in your opinion, on how this technology is not deemed sufficient for control purposes in a factory setting?
Sure, I'll ask my colleague, Dr. O'Mahony, to address that one.
Sure. So this tool, it's a control tool, Deputy, which does add some assurances. For example, the risk of fish being put over the weighbridge without a flow belt, without the flow belt being even turned on. It manages that risk if we can see the flow belt moving and the clocking up, basically. But there are risks which it does not manage. So risk that flow belt might be underweighing. So a kilo might be coming up as a kilo. So it has some assurances. As with all control tools, there's no absolute control tool that provides 100% assurances. They help, but they're not unto themselves a 100% solution.
Okay. Should not you, as a sole member of the board of the SFPA, support stakeholders in their view that commercially sensitive information coming into the hands of the SFPA should not and must not be shared with the public other than in accordance with the law?
I would agree with you, Deputy, yeah.
Is this data that is held by the SFPA not subject to the laws on confidentiality of data and data protection of both the EU and Ireland?
Yeah, yes, it is, Deputy, yeah.
Okay, thank you. And we'll say...
So can I just clarify which data it is particularly, Deputy?
Different data that comes before you. Like, is it protected? You know, it doesn't get out to the general public?
I may be wrongly construing something, but if you're referring to the CCTV data, we don't hold those data.
Okay, right. Just in relation to Mr. Hayes, you might inform the Joint Committee as to your own appointment from the AFM to the head of the SFPA to replace the outgoing Dr. Susan Steele, who sat on the interviewing panel. And how many other candidates were interviewed?
So I actually don't have that information, but I'm not sure that the chair would consider it.
No, Michael, that's not the subject that we're dealing with now.
Okay, right. I have enough questions for now. Yeah, thank you.
Okay. Deputy Doherty, and again, 15 minutes max, and you can feel free to be under it if you want.
Thank you. Good morning, Chairperson, and welcome to guests to the committee. So just take me through this. Obviously, my background is in fishing, or it's not my area of expertise in terms of my brief here in Leinster House for a while, but obviously this is an issue that is causing serious damage, reputational damage, and loss of jobs in my community, in the community of Donegal, and it could have wide-scale implications in other areas. So you mentioned in your opening statement that there was a campaign of disinformation, misinformation in relation to the SFPA and the provisions of the Northern Ireland Protocol. So can you explain to me, just because we're talking about kind of Section 61(1) and so on and so forth. So in relation to the North, right, what is the status of the North in relation to Regulation 1224 of 2009? That's the first question.
I can hopefully answer your question, Deputy. So the status of the Northern Ireland in respect of, I presume we're talking about Article 61.
No, just the whole regulation, particularly the scope of the regulation. The scope of the regulation applies, does it apply to the North of Ireland?
Parts of the regulation apply to the North of Ireland.
Under what, how does it apply to the North of Ireland?
So under the Northern Ireland Protocol, there is the annexes of the Northern Ireland Protocol have a series of, a big long list of regulations which apply, which Northern Ireland implements.
Okay, and some of, under the Northern Ireland Protocol, obviously, which designates Derry as a port for landing and so on and so forth. So what part of the regulation, what part of the regulations apply? Because obviously under this regulation, in terms of the scope, it seems to apply to member states.
Yes, It seems to apply to it explicitly applies to member states, and the Northern Ireland Protocol does not designate any port. It doesn't get into that level of detail.
So it applies to member states of the European Union. So does that include the north of Ireland?
The Northern Ireland has. So yes.
Yes. So the regulation comes fully under so it applies. So the north of Ireland is a member state as defined under this regulation. Is that correct?
Essentially, yes.
Essentially, yes or yes.
Well, there are connotations to that, but for the purpose of today's discussion, fish weighing, yes, without any qualifier.
So who's the competent authority in the north?
Well, my understanding is that that competency is allocated to DERA NI.
Oh, okay, so the Department of Agriculture in the north. So they would carry out, they have the responsibilities under this regulation to make sure that, just like you are making sure that fish are weighed in killibags, that they have the responsibility to make sure fish are weighed.
I can't speak with any authority to the delegation of authority.
Okay, do you have the authority?
Do
you have the authority in the north?
No.
Okay. So you say under that fish can be purchased from the north, yes, by a processor in killibags or elsewhere.
Yes.
But it has to be, what is it, weighed in the north first, in Derry or Belfast or wherever it's coming in?
Yes.
Okay. And who's responsible for ensuring that it is weighed? Is it yourselves?
The operators.
Who?
Weigh the fish. The operators weigh the fish. The responsibility for the accuracy of weighing rests clearly with the operators.
Okay. But who's the authority to ensure that that is happening?
So the competent authority for fishery control in Northern Ireland, which I believe to be DERA.
So when the Ingrid Magella came into Derry, because it was prevented from coming into killibags and being able to offload its fish in a manner that would be still available for human consumption, was the fish weighed in Derry?
Deputy, that's number one. It's a particular case, but I must take issue when you say that it wasn't allowed to come into killibags because...
in a manner, I qualified that in a manner that would allow for the fish to be available for human consumption.
And I take issue with that as well.
And I take issue with the fact that you take issue with it. But going back to the point, was the fish weighed in Derry?
So we're now speaking about a specific case,
yes.
Deputy. I would be more comfortable talking to generality, but if you're asking me about a specific case, is it? Okay.
Well, how would you know? How would you know if so? Does processors purchase fish in, like, is this routine? You know, where processors will purchase fish that have landed in Derry in the past.
Routine. It's not abnormal.
It's not abnormal. Okay. So how many times has how do you ensure that the regulations, which has nothing to do with you, because it's the Department of Agriculture in the north, are supposed to do, you know, your job. That, you know, you're not concerned about if fish has been landed in France or in Spain or in wherever. You've got your job to do in terms of the jurisdiction that you're the competent authority. So how are you able to ensure that the fish weren't, are all the landings that happen in Derry that are purchased by processors in killibags, are they weighed in Derry?
Okay, so they should be weighed in Derry. They should be weighed at where they land. If they're landed outside of the jurisdiction, then they should be weighed in the jurisdiction.
So how are you notified of whether are you notified of whether they're weighed or not?
So an explicit notification of whether they're weighed or not does not come to us, but it's a moot point, Deputy, because they can't be weighed in Ireland.
They can't be weighed in Ireland?
They have to be weighed before they get here.
Yeah, but they can be bought by Irish processors.
They most certainly can.
Okay. So how do you satisfy, if there's been 100 landings at the start of the year, how do you satisfy yourself that all of these landings have been weighed in the port that they landed originally?
So the controls in the port in which they land are a matter for the port authorities of that.
Yeah, but you decide then, because you decided in a case, which is a unique case, to strip away the weighing licence of two operators because, loads of publicity, RTE were showing up what was happening in relation to this dispute.
Absolutely.
Has it happened in any other case where fish has come into the port of Derry and purchased by processors in the 26 counties?
So fish being landed to Derry and purchased by processors in the 26 counties can happen legitimately, provided it's been weighed in Derry and the weight that's obtained in Derry, for picking that example.
And that's the question. We know that. That's the question. How do you satisfy as the SFPA that is happening or not? Because you went out of your way obviously, in some way, to find out that it didn't happen, or we can only read. I'm not suggesting that it didn't happen, but you obviously have assumed that it didn't happen because as a result of that, you have taken off the weighing licences of 2 operators in Killybegs.
Deputy, we're seriously straying into an area here that we're not comfortable in. We're talking about 2 particular cases here. We're talking about 2 particular cases where it's likely that files will be forwarded to the Director of Public Prosecutions, and we would prefer not to talk about individual cases.
Okay, talk to me about the procedure. You've mentioned that it is common for fish to be landed in a jurisdiction and then purchased by operators. How does the SFPA have intruded in another jurisdiction? How do you satisfy your routinely? Convince the committee that this isn't vindictive in relation to what the SFPA has done as a result of the controversy that is going on in Killybegs, which is very serious, and I respect your point in terms of straying into individual issues. But there's many individuals who lost their jobs, who didn't have employment as a result of the decisions that are being taken. There's many companies that are in serious jeopardy with big loans out, wondering because of the reputational damage that have happened. So what are the procedures for the SFPA and convince the committee that this was not vindictive in relation to this landing, and that what are the procedures to look at all of the landings that have happened in the past? Because it's my information that that the procedures that you have done have never been used in the past before.
No, we won't accuse them of being vindictive. We'll ask
no,
them
I'm asking them I'm not accusing them of being vindictive. I'm saying convince the committee that this wasn't vindictive. That's my point.
I have no problem when you ask him to go through the procedures.
Yeah.
But your main implication is vindictive. I'm not. So you're perfectly trying to go through the procedures. What procedures are operated in an Northern Ireland port?
But definitely, I mean, this is about sustainability of fish stocks at the end of the day, right? It's about making sure that there's an accurate account of the fish that are being killed and landed. So we have many fish stocks off the coast of Ireland. Each of those stocks is assessed by scientists, and a calculation is done to figure out how much of that stock can safely be taken out and landed.
I am not questioning that. I agree 100% with you. And indeed, the fishermen that I speak to also agree, because the preservation of those fish stocks and management of them is their livelihood. The question I asked you is in relation to procedures in terms of landing in Derry. What are the procedures in relation to notification? How the SFPA have identified whether weighing has taken place or not? What are the procedures then that alert the SFPA to decide to follow up action in relation to processors that may have purchased fish that were landed outside of the jurisdiction?
Sure, and we'll get to that in a second, Deputy, but if I can just finish the point in relation to sustainability. If the fish isn't accurately counted and if that stock is overfished, then it's not just the constituents that you're talking
Nobody
about
is
at the moment.
that with respect.
It is for many years into the future. It has already happened with some fish stocks off our northwest coast. So if there isn't an accurate count of the fish, whether they're being landed in Ireland or in
We all
Northern
want an
Ireland,
accurate count. Please talk to me about the procedure. Just take that as read. I want an accurate account. I want you to do your job to make sure it's an accurate account. That's fine. Take that as read. I'm asking you about the procedures, and then I'll come into the weighing mechanisms in Killybegs.
Okay. So we're speaking to the generality of fish landing to Northern Ireland and our procedures regarding our controls if that fish were to arrive back in Killybegs. Yeah?
Yes.
So we have roles there. Northern Ireland authorities have roles as port state. The flag state has roles. The state that has given the fishing vessel license to kill those fish has roles itself. So there was a flag state here. There was a port state here. There was Northern Ireland. We have roles in our jurisdiction for being responsible for controlling the first purchaser of those fish. So we carry out checks of the data provided to us by the first purchaser. It's a likely scenario. I'm not going to speak to individual scenarios, but in the scenario of the transporter being present in Ireland, then we have a role as the member state responsible for controlling the transporter. So both the transporter and the first purchaser are obliged to make declarations to us. We assess those declarations to assess whether the fish have been weighed in accordance with the weigh regulations, to assess whether their declarations, which are obliged to be the same as the weigh records, we have to assess the accuracy of those declarations in both of those instances. So we make checks to ensure the accuracy, to the best of our ability from the data available to us, of those data. And those are the procedures, Deputy.
Okay. You may maybe inform the committee of the landings in terms of how that procedure was applied right throughout maybe the last year, just to ensure that it wasn't just one-off. But I want to go into the options and really what's at the nub of this here, just to complete my questioning. You mentioned in your opening statement, Mr. Hayes, about that the High Court has deemed, obviously, the industry weighing system as operational or as fine. Is it the case that the issue of that not being able to be used as a mechanism to weigh blue whiting and other fish is that it is industry owned? Is that at the core of the issue?
Well, I guess just to be clear, Deputy, what the High Court has said is that there's no reason that we can't permit that weighing device.
Yeah.
And that weighing device has been permitted and is available for use for the 95%, the 19 out of every 20 landings that come into Killybegs, if the operator chooses to use it.
But we're talking about the 5% here.
Yeah.
Is that weighing machine, if it's properly calibrated independently, can that be used if we got over the anomaly of that it's industry owned?
So what the control plan says is that weighing has to be conducted on a device that's non-industry owned, non-industry operated, such as a weighbridge.
Okay, so the industry has offered the SFPA to purchase that or to gift that to the SFPA, is that correct?
Well, it's sort of correct, Deputy. It's not fully correct. My understanding of what happened there was that there was a lot of interaction with the industry on the lead up to the control plan being agreed last December. On the 9th of December, there was a meeting between the industry and the SFPA where it was pointed out that one of the conditions that the Commission were insisting on was that the weighing device would be non-industry owned, non-industry operated. There was a further meeting with the catching side of the industry on the 4th of February, where options in relation to the ownership model of the weighing device were discussed. There was a follow-up to that meeting on the 11th of February from the catching side of the industry with a lease proposal in relation to leasing the machine. There was a further meeting on the 21st of February with the processing side of the sector, where they informed the SFPA that the catching side of the sector had no authority to enter into any lease arrangement and that any such offer was withdrawn.
Okay. Thanks for informing us of that timeline. Can I just go...
sorry, I should add, Deputy, that at all,
just the last question.
That at all points in that process, the SFPA made clear that to be compliant with the control plan, that the 5% controlled weighing on landing had to be carried out on a non-industry owned, non-industry operated device such as a weighbridge. Fully
aware of that. If the industry were willing to either lease, sell or gift the machinery, notwithstanding the complexities that you've outlined, would the SFPA be able to operate that and therefore allow for that?
In my opening statement, Deputy, that I said that we don't weigh fish, we supervise the weighing of fish.
Okay.
So we're not interested in leasing or owning a weighing device. Our role is to supervise the weighing of the fish.
But to try and save jobs, help the industry, make sure that vessels that are turning away from Ireland, would you not look at this as a compromise? If the department owned it, if a charity owned it, you know, would the SFPA be happy?
Suggested in relation to this, keeping in mind that what the control plan says is a non-industry owned, non-industry operated weighing device such as a weighbridge.
Okay. Thanks, Deputy Doherty. Deputy McLaughlin is next.
Thank you, Cearla. First question is, the EU Commission in their recent stats have rated Ireland as the most compliant member state in the EU in terms of fishery regulations. Would you agree with that? Is that correct?
I'm not aware of what you're referring to, Deputy. Sorry.
So, so just to repeat again, the EU Commission are saying that Ireland is the most compliant member of the EU in terms of fishery regulations.
Saying in what, Deputy? What are you quoting from?
In their recent stats. Are you not aware of that? No?
No, Deputy, sorry.
So you have no awareness that Ireland is the most compliant state, yet that's on the record, that you, the SFPA, have no awareness that Ireland is the most compliant state in the EU in terms of fishery regulations. Is that what you're saying on the record?
I haven't seen the public.
No, that's not what I'm asking you. You are the SFPA, you know. Is Ireland the most compliant in the EU? Surely you must know that.
Well, I'm not sure what metrics were used to measure that, Deputy.
Okay.
And I mean, without knowing the metrics.
So the answer is you don't know.
The answer is I don't know.
Well, that's on the record. Thanks. Now, the next question I have for you is CCTV. I've seen this with my own eyes in a factory in Killybegs. Is in one factory, I understand there's 10 CCTV cameras that are accessible to the SFPA officials at all times. So they can sit in their office in Killybegs and in real time monitor the weighing and the operations that are taking place within the factory. Is that correct?
Well, it's a condition of the...
No, that's not the... is that correct, yes or no?
I don't know what plant you're talking about, Deputy. I don't know how many cameras are in that particular plant. What I do know is there's a condition in the permits for the processors in Killybegs that they must deploy CCTV to monitor the flow scales,
right,
and they must be left on for the duration of the permitting. Okay,
so you do have access through CCTV to a factory, at least one factory in Killybegs for the purposes. You've said that in your opening statement anyway. Thank you.
Yes.
Now, in unannounced inspections, are you able to make unannounced inspections in any factory, relevant factory in Killybegs?
Yes, Deputy.
Okay, thanks. Now, can you just tell me, are you aware of anywhere else in the European Union where a fish processor has CCTV cameras in place, monitored by the regulator, and that is stored for around 30 days? Can you tell me any other EU member state that has that in place?
So just to be clear, Deputy, we need to back up a little bit here, and we need to
answer that question first.
I'm going to answer for you, Deputy. Yeah. We need to go back to April 2021, when the Commission revoked the control plan that we had in place because of serious reservations about the misrecording of fish, particularly with bulk pelagic landings.
We're short on time. Could you answer the question,
Deputy,
please?
But I am answering it, Deputy, if you give me a chance.
Yeah.
So we came to look at a new control plan at the end of 2021. One of the conditions that the Commission attached to that, in light of their concerns, was in relation to how the permitting was to be done and what conditions were to be in it. It arose from...
But I didn't ask you that question with respect. I asked you, are you aware of any other EU member states, fish processing factory, that has that applied to them by the regulator? Is that the case anywhere else in Europe? If you don't know, that's fine. You can just say you don't know. Okay, I'm going to assume... if you don't know,
we don't know for sure, Deputy. I mean, we can't speak for control authorities in other member states.
Just to recap, I understand that the European Commission say that Ireland is the most compliant state in all of the EU in terms of with regulations. Number one. Number two, we have a level of oversight that is unprecedented anywhere else in the EU. You don't know. I'm going to state that I believe it to be the case. Okay, so that's the level of oversight the industry faces. Yet we face this debacle then that you're in negotiations with the industry around the pier-side flow scale system. So you're in negotiations with them. These negotiations, these agreements break down. It goes to the High Court. I'm just going to quote from the High Court judgment. So I'm going to quote from it here now directly. Judge Garrett Simmons. He stated, "The Sea-Fisheries Protection Authority has acted ultra-virus by continuing to withhold approval for the pierside weighing facility at Killybegs Port by reference to the ownership concerns raised by the European Commission. There is no legal basis for these concerns, and the Sea-Fisheries Protection Authority has not sought to argue otherwise." That was 4th of June 2021, 4th of June, almost a year ago. Now, that was surely an instruction at that time for you to regularise the situation, for you to ensure the calibration and certification of said weighing system. Do you accept that your failure to do that has created the difficulties that we're in now?
So we haven't failed to do that, Deputy. That machine is certified.
But have you taken control of that system?
What does the judgment say again, Deputy, about taking control?
But when you say, have you taken control of the system? Have you done the natural thing?
No, Deputy, we don't weigh fish.
Okay.
The judgment
Can I ask, prior to that judgment, did you convey any concerns that the problem was that this was not in the control of an independent body? Was that your concern prior to the High Court decision?
Deputy, I think you might be confusing two different issues here on my understanding of it, certainly.
Yeah.
I mean, I wasn't...
Well, I'll put the question again, right? Did you articulate, prior to this matter going before the High Court, unfortunately going before the High Court, did you articulate that your difficulties were that it was in the control of the industry? That was what your concerns were before it went to the High Court. Is that correct?
Yeah, but it went to the High Court, Deputy. There was a judgment that said there was no reason for us not to certify the machine. The machine was examined and is certified and can be used for weighing fish. So for the 95%.
Now, in your opening statement, you allude to and you say it openly, your frustrations about the length of time it took to address, and it's just peculiar that the European Commission, would you agree it's a bit peculiar that the European Commission had not articulated any issue with an industry-owned system, but all of a sudden it had. Is that peculiar to you, that it had just done after the High Court decision? That all of a sudden that your dialogue with the European Commission, the correspondence from the Minister, Charlie McConlogue, to the Commission assures them on that it isn't industry owned, but they hadn't raised any concerns prior to this High Court case. You know, is that peculiar to you? No, where did this come from? Nowhere in the European Union. Nowhere in the European Union does the requirement for a weighing system to be, it doesn't. This requirement that you negotiated with the European Union doesn't exist in any other member state. Is that not peculiar that it would apply? That the concerns of the European Commission all of a sudden align themselves to your concerns? Not peculiar, no.
So you're referring to June 2021 decision of the court.
So I'll summarise it. So in my understanding is your objection is that this weighing system is owned by the industry. It goes to court. The judge makes a clear decision that you're acting ultra-virus in the way that you're dealing with this. And then all of a sudden, the European Commission all of a sudden starts to share your concerns. And you do not at any time avail, it's been said publicly in all sorts of fora that the industry wants this to be taken away from their control, that they are happy for this not to be in their control. Absolutely no problem for it to be controlled independently. I think that's what we all would want. So why was that not implemented? Why was that not addressed? Why was another barrier to resolving the problems of Killybegs? In that interesting period of months, why was that not implemented? So the High Court, it's a damning decision by the judge against the SFPA, acting ultra-virus. That's a very serious matter. And you don't then seek to regularise it, take control of the weighing system, clearly demonstrate to all concerned parties this is an independent weighing system. There's nothing to see here. We have CCTV cameras in all these factories. We are the best regulators in all of Europe. We're actually really good at our job. There's nothing to worry about here, European Commission. We've got CCTV cameras, unannounced inspections, a level of oversight unprecedented in any other industry in Ireland, unprecedented in the industry throughout Europe. That's the level of oversight we've obtained. And all we're going to do now is make sure that this weighing system is outside the control of the industry. Why did you not resolve all those issues rather than all of a sudden more barriers appear? Just if you could answer that.
So I guess there's a few things in what you said there, Deputy. I mean, one of them is you're saying that the industry want to transfer ownership of the pure side weighing device. That's certainly not the last way that we left it with the industry. As I said at the meeting on the 21st of February, the owners of the machine said they weren't prepared to enter into a lease arrangement on it. We haven't heard anything different in the meantime. In relation to the High Court case, it was, and you read out the judgment, Deputy, it wasn't the court's view that the SFPA or any other state body should take ownership of the pure side weighing device. It was indeed, as you say, that we were acting ultra vires by not permitting the pure side weighing device. It was subsequently permitted, and we were in full compliance with the judgment of the court.
I have here a copy of correspondence that has been sent to you on the 5th of May, Mr. Hayes, from the SFPA Consultative Committee. As you know, that they are in place on the legislation that you are under, and they have grave concerns about how this has all been handled, about the lack of consultation with them, as you'll be aware. But they clearly state in this, they're clearly asking you if the ownership of the flow scales in the pier in Killybegs is transferred to non-industry owned and non-industry operated systems, can the SFPA confirm whether this meets the requirement of the interim control plan as stated above? See, you mean, this is it in writing, that it's clear that the industry want, like I have to say, in all my talks with the industry, in all my discussions, as is my responsibility as a TD for Donegal, but also I'm the Sinn Féin spokesperson on fisheries, it's been made clear to me that they don't want to have possession, ownership of this weighing system, that they want it to be, that what they want is a solution. I mean, I'll put this to you, Mr. Hayes and Mr. O'Mahony. I mean, what industry in this country would allow round-the-clock CCTV monitoring of their workers and their operation by a regulator? But they are agreeing to that. They have accepted that. That's the level of oversight they have accepted. So you're not talking about an industry that's resisting cooperation at this point. So you have an industry that allows that level of oversight. It's unprecedented in the European Union, and an industry that's saying, take possession of this weighing system at the pier. Take it away from us. We don't need it to be industry owned. Will that now, finally, for God's sake, address whatever concerns are out there about oversight? I have to say, I have no tolerance for illegal fishing. I have no tolerance for an unsustainable approach to our fisheries. I think it's a precious resource. I think you do a really, really important job. But the damn thing is, I think you do it well, according to the European Union. You know, the compliance level in Ireland, I think, is 98%, as I understand it. So we're not a rogue state. We're not the Wild West in Ireland. We're actually hugely compliant with regulations. You do your job really, really well. So what I'm trying to get to is, can we come to a point that we solve this issue in Killybegs, address the concerns of the European Commission in a sensible way? I mean, the level of oversight, you guys, is incredible that you've obtained in Killybegs. That's fair enough. They accept that. That's what was needed, apparently, to deal with the concerns that were there about practices that may have taken place in the past, illegal practices. But today, in the year 2022, the level of oversight you have is incredible in Killybegs. That's what you've obtained. Why can you not take possession or find some way of those scales get into independent possession that addresses the concerns of everybody? Could you just get to the crux of that issue?
So Deputy, as I said earlier, there was initiatives in relation to a lease proposal on the 11th of February of this year. It was followed up with an absolute certain, at a meeting on the 21st of February, an absolute certain position that the owners of the scales weren't prepared to transfer them, and that the people that had been suggesting that they be leased or transferred didn't have the authority to do that. In relation to the consultative committee, Deputy, I'd ask our Director of Transformation to address you on that one.
Thank you, Mr. Hayes. Deputy McLaughlin, I have responsibility for the relationship with the consultative committee, and that's a relationship, it's one that we recognise the value of. It is really important in terms of ensuring that consumers across the world can have confidence in the provenance of Irish fish. It is important from the point of view that while there will always be a friction between the industry that's regulated and the regulator, we do need to work together to find solutions that benefit everyone, that benefit Ireland Inc. and that benefit coastal communities all around the country. You spoke there about transfer of ownership. In this and following up from that February meeting, at a subsequent meeting with the Consultative Committee, we invited them to put a proposal forward in relation to ownership. We are still waiting for that proposal.
Okay. But fair enough, yeah, no, I'm happy to give way. Thanks, Chairman.
Deputy Senator Lombard is going to take the chair for me as another engagement. Deputy Pringle and then Deputy Sherlock.
I'm just conscious, Chair, that I'm not a member of the committee, so do members have precedence over me? And I'm happy to come in last.
There's no other member looking to speak.
Thank you, Chair. Thank
Deputy
you.
Pringle.
Thank you, Chair, and I'd like to thank the representative for the presentation here today. A couple of things just arise from your statement there, and what's going on here at the committee meeting. I welcome the fact that you withdrew the paragraph at the end there. I think that's very sensible. I just wondered, there's another paragraph then under section 4 in the second paragraph where you say that several instances of weight unit manipulation result in temporary revocation of permits until necessary enhancements were made, including one subsequent conviction. In no case of manipulation was there any particular deviation between the declarations of masters, purchasers or weighers. Is it not the case that the weight of what had been landed would be based on what it weighed at the factory in that case, so that therefore is that not calling into question people that shouldn't be called into question as well?
Well, I guess what we're saying here, Deputy, is that if there was a manipulation in one case, you would expect that the other two operators involved in that, that their tallies wouldn't match, that there'd be different weights recorded by the other two. But what happened?
Are they not based on on the figures that the factory records anyway? The landing figures are based on the figures that the factory records in the case where the weigh-in takes place in the factory.
Yeah. Do you want to take this?
Sure. Yes, so that they're obliged by law to match, by Article 60.5 of the regulation to match. That weight shall be used.
Okay, that's grand. Thanks. And in relation to you go on then say that the audit formed the view that there was a risk of non-compliance, and that the SFPA finding that the SFPA wasn't sufficiently robust either. What was the default fault of the SFPA in relation to that?
That was in the. Sorry, Deputy. What paragraph are you on?
Paragraph 4, 2, 3, 4 on Article Section 4.
Okay, so this was an audit of control of pelagic landings in 2018. So there are various concerns arose from that. And the overall concern is, as we've highlighted there, is that our controls were not sufficiently managing the risks of under-declaration in those pelagic landings.
So you weren't doing your job properly, based on the audit?
Well, our job is control. Compliance isn't ours to give. Compliance is the industry's to give. Compliance arises from the actions of industry, not from the SFPA. But our job is to have a control system that minimises those risks. We had an array of controls, as Deputy O'Loughlin, for instance, has highlighted, including, for example, CCTVs, significant controls, and the view of the auditors was that there needed to be more.
So you weren't doing your job properly, that's what I'm saying there, basically.
We were doing a difficult and comprehensive job, and the view of that audit was that more needed to be done in order to manage the risks of pelagic under-declarations.
Grand. Just in relation to the 5% that is required to be weighed, or 5% of bulk landings, or bulk pelagic landings, or 7.5% of fish quality. I presume it's 5% of landings. If that 5% has been reached, is that the end of your inspections then on 5%? So would you do 10%, 20%,
All right. Okay.
30%?
So the regulation, the control plan, which builds upon the regulation, sets that out as a minimum for full inspections. That's certainly not the totality of our inspections. And again, I thank Deputy O'Loughlin for referring to the broad array of controls we have in place. Covering, because effectively, Deputy Pringle, 5% is still just 5%. There's no point in having an entire focus on the 5% of landings. If 19, 20 landings are going up the road to be weighed up the road, then we need to be there also.
Oh, yeah, I understand that, but the 5% that you have to do, weigh 5% on the pier, once you've reached that 5%, that's your requirement reached.
That is the benchmark reached then, Deputy, yeah, but it doesn't mean that we won't be inspecting more than that. Our inspections are risk-based, but to comply with the control plan and to unlock weighing 95% of the fish in the factory, it is required that 5% is weighed on the pier site or the supervised landing.
It is required, so in some circumstances that could be 20% would be weighed on the pier site.
It would be unlikely that it would ever reach 20%, Deputy, but it is possible.
10%?
It's unlikely, Deputy. Unlikely. We would have, I can't quote, I don't have data in front of me, but I can tell you that it's unlikely we would ever go very far beyond 5%.
Very far beyond it. So the 5% is only just a guideline. It's not a figure that you want to achieve. 5%
is set out in the control plan, and that's a pivot or a reference to Article 107 of Regulation 404 of 2011, where 5% and 7.5% are.
But if at the end of every year, if there's 100,000 tonne of pelagics landed and you've checked 5,000 tonne of them, you're compliant as far as...
Well, it's referring to the tonnes now, it's 7.5.
Oh, it's 7,500 tonnes.
Yeah.
Well, 5% of the landings, that's what I was asking. So, or 7.5%.
But this is a part of our overall control.
So if the quota is 100,000 tonne, at the end of the year, you've checked 7,500 tonnes, and you're happy enough.
Portion of the landings, Deputy, not the quota.
So of 7... So, so if there's 1,000 landings at 7.5% of 1,000, you have to get... Yeah,
so it's 5% of the landings, Deputy, 7.5% of the fish. And just to be clear about it, it's each species within that then.
Right, okay. It's clear as mud.
Maybe some numbers would help, Deputy. In general terms, there are 600 pelagic landings. 5% of 600 is 30. Right? I trust that is helpful. In general terms, there's probably roughly 80,000 tonnes of pelagic fish, so 5% of 80,000 tonnes. I can't do the sums in my head. 7.5% of 80,000 tonnes. I can't do the sums in my head.
It's probably about 6,000 tonnes. But
Deputy, we keep, I know we keep harping back on it, right? But we need to keep in mind the bigger picture here, that this is about the sustainability of fish stocks going forward. So, I mean, whether it's 5%, 6%, 7%, you know, it's still about making sure that too much fish isn't taken out of the sea, so that resource is there perpetually going forward for future generations. And like our job is to make sure that the operators are weighing those fish accurately for that very reason.
Yeah, aware of that. Thanks. In relation to the scale, the weighing scales is on the pier, you say that you have nothing back from the industry in terms of offering an ownership of it or stuff like that there. Would you take a view in terms of who the ownership of it would be? Or would you take it, so if the industry came back and said, we want Joe Bloggs to own and operate this machine, are you going to accept that Joe Bloggs will do it? Or do you say that Joe Bloggs is too close to the industry, or he's too work for him? You know, is he based in Killybegs as a problem, or should it be based in Donegal Town, or should it be based in Dunlow, or or Galway? What's the requirements of the person that would be the operator of the scales?
So Deputy, like I don't want to get into the parameters that might or might not work here. I mean, I am emphasising when I've answered the other deputies' questions that it does say in the control plan, such as a weighbridge. A flow scales is a long way from a weighbridge.
Yeah, but such as a weighbridge isn't necessarily, it doesn't mean it has to be a weighbridge.
I agree, Deputy, yeah, but look, there's other parameters to be taken into account here. What we have asked the industry to do is to put proposals forward, and we will examine those proposals, but I'm not giving any further guarantees in relation to that. When we see the proposals, I've undertaken that we will look fresh at them, but I wouldn't like to give the impression that it's as simple as transferring the owner from A to B.
Okay, so right, so you have to see what comes forward from the industry if anything does come forward. Okay, in relation to the land, one of the problems with blue whiting and stuff like that there in Killybegs, and if blue whiting is going for human consumption, it's required a different handling than if it's going for fish meal and stuff like that there, and it actually makes a big difference to the crews and in terms of wages as well, because the blue whiting for human consumption gets a lot bigger value when it goes to factories. So weighing a full vessel of blue whiting means basically that, in the view of the fishing industry, and you may argue, and it would be interesting to hear if it does or not, but you may argue that it doesn't prevent it going for human consumption. That's a moot point, but basically the way it works at the minute is it goes to fish meal, which makes a huge impact on the crew of the boat in terms of their income, and makes a huge impact for workers in the factories in terms of that if there's work available or not. So there's something wrong with the way blue whiting can be worked. Is it your view that blue whiting will work through the scales that is there on the pier? Or if not, would it be possible, and why wouldn't, and if it wouldn't be possible, why not? Could the 5% be checked on every vessel rather than picking out one vessel out of 20 to actually do your 5% on to 20 vessels rather than 1 out of 20?
Yeah. So Deputy, there is certainly a debatable quality which I'll ask Dr. O'Mahony to address in a minute. But I guess just to say that it is our view that the one of the options that is available in Killybegs at the moment would accurately, in fact very accurately, weigh the fish without affecting the quality. We do have interactions with the industry regularly. One such interaction was one part of the industry willing to use the pier-side device to use option 1, as I outlined in my opening statement, which is pump the fish into the pier-side weighing device, put the fish into a pre-weighed, pre-watered tanker, bring it to the weigh bridge, weigh it again, subtract one from the other, and that's the weight of the fish. He wanted to put 2 stipulations on that. He wanted to also switch on the weighing facility on the pier-side device, which I agreed with, on the basis that the official weight would be the one obtained on the weigh bridge. The other one would certainly be a good reference, but it couldn't be used as the official weight. And secondly, he wanted to photograph the fish to see if there was damage to it or wasn't damage to it. Now, the agreement was that that would be done. I don't know why it was never done, Deputy, but it wasn't ever done, and I think that's a pity, because I think it would have given us a lot more information in relation to how that scales will operate, and whether indeed the fish would be damaged, and if there was damage, as would be shown by the photographs, what modifications could be made to the scales to minimise or eliminate that damage. But perhaps Dr. O'Mahony could talk about preserving quality of fish for us.
Sure, I'll speak to that question, Deputy. I might firstly speak to the last part of your question, which I'm going to paraphrase and try. So, as I understand your question, could we deal with some of all landings rather than all of some landings?
Yeah.
Yeah, and the answer is no. The regulation is worded 5% of landings means we have to conduct these type of controls on all of some landings. It's not sufficient to do it on some of all landings. I hope that's so that's effectively no to your answer. So that's the way the regulation is worded, and the control plan refers directly to when you're doing those inspections according to Article 107, they are going to be done this way. So because it pivots back to Article 107, the answer to your question in the regulations, which the legislator, including yourselves, have given to us to implement, the answer is no.
Okay, and so in order to change those regulations, where would you have to go?
Well, it's an EU regulation, Deputy.
So it would be the Commission?
Yeah. well, sorry, no, well, there's different EU legislation.
Well, we
formation
know the
processes.
Commission makes laws, so
Well, there's an entire EU legislature, and I think that's a bit simplistic in fairness.
well, I wouldn't think so, but we can argue about it anyway. But that's a separate.
Could I speak to the quality question, Deputy? Or would you still like an answer to the quality question? Sorry.
No.
Okay, so look, you attended both. Well, several of the deputies here attended both of our previous appearances, our most recent appearances before the committee, which we're happy to do in 2021, where there was no control plan in place. So in no circumstances SFPA ever disputed the view that there could be a negative impact on quality arising from weighing. We'd never gone there. And I think that's manifest in our pursuit of initially the 2012 control plan and then the 2021 interim control plan. So we went after these in order to address potential quality concerns. We see the benefit of allowing weighing to take place after transport. We do. Okay. I'd like to try and approach your question in two kind of answers. One is the proportionate, the numerical concept, then and also the practicality of that. So just numerically, what we have here is a requirement to weigh 5% of 600 landings in a certain way, and that's what's in contention here. We're talking about the 5%, is a quote from earlier on in the day. And we've set that out that we genuinely accept that there is a real challenge in meeting the weighing accuracy and the quality maintenance obligations of a fisherman when they're conducting those 5%. We accept that. It's not a it's not something we contend. As my colleagues have as Mr. Hayes has pointed out, we have offered an option that we believe best manages those, and that hasn't been taken up. So we point out the context of any detrimental impact on quality in the overall context of 100% of landings. The alternative of 100% of landings, 5% of 600 landings is a much smaller figure than 100% of 40,000 landings.
Yeah, but it makes a big difference if you're a crew member on the boat that's doing it. It makes a big difference.
So then this issue of blue whiting, and yes, there are different species. There are 4 species, and blue whiting, it would be reasonably described as a soft fish. There are different fish. Blue whiting is different to horse mackerel, is different to boarfish. They're different creatures for sure. But I think it's useful to maybe describe the totality of the food chain to the committee. And in reality, once these fish are trawled at sea, the net is pulled up alongside the vessel, and the fish are pumped on board using a high-pressure pump, a high-volume pump.
Yeah, I know. I'm sorry. I just have one last question. That's a very quick question.
Well, I'd like to.
I'm sorry, my time's run out. Maybe we can go back to it.
Go back to the second.
Just one last final question. I had it. Where did I get it now? I had it written down here now. Oh yeah. If the factories were based on the pier in Killybegs, would we have this problem?
That's a hard question to answer, Deputy. I mean, it might be a short question, but it's a hard question to answer. But for sure, in other jurisdictions where they land bulk pelagics and where the factories are based on the piers, there is different arrangements in place that certainly aren't as complicated as the arrangements that we have in Killybegs.
So basically, yeah. Okay, thanks. No, that's grand.
Yeah, Deputy Sherlock.
Thank you, Chair, and I
major
welcome.
marine part of Cork, obviously.
Pardon me, Chair.
You're from a major marine part of Cork.
I represent fishers as well, Chair. I'm just glad to have this opportunity to be in this committee today, and I'm trying to get a deeper understanding of the culture and the dynamics that exist between fishing communities and your good selves as the SFPA. What I've seen so far is that, and I think you'd agree with this objectively, is that there is a tension that exists. The word tension, I'm using that word, advisedly. There's a tension there. And I just need to have a better understanding of the governance arrangements and, the statutory functions of the SFPA in respect of its relationship in the first instance with the community as represented by fishers and processors, and also in relation to this consultative committee. Okay, so my understanding, Mr. Hayes, is that you are the executive chairperson that gives you are the boss, as it were, to use a colloquial expression. Yes or no?
Sorry, Deputy. I wasn't. Yeah,
He's tuned out already, and I'm not even 2 minutes in.
I was writing.
Don't worry, I'm only warming up.
I was writing your questions, Deputy, so that I wouldn't miss them, but
Thank
I
you.
didn't realise you'd stopped talking. My apologies. I am indeed the Executive Chairman. The structure that's set out under the Sea Fisheries and Maritime Jurisdiction Act 2006 is that the Sea Fisheries Protection Authority is an authority of at least one and up to 3 members. From amongst those members, the Minister selects a chair. I am the chair, but as it happens, I'm also the only member as we speak today.
So you are de facto the boss, yes or no?
I'm the exec. There's a lot of people could think they're the boss in there.
No, let's...
I am the executive
it's
chair.
a serious question, and I'll tell you why, Chair, it's a serious question, because I'm trying to get to, within 15 minutes, some clear understanding of the dynamics that inform the organisation.
Okay.
Are you the boss or not?
So the executive chair is the equivalent of the CEO.
Okay.
And before we move off that...
That explains it. Bear with me. No.
Can I just say...
Chairman, I beg your protection here now. I'm going to be very respectful, and I'm going to ask for brevity in the answers. And that's all I ask for, and I say that with the utmost respect, because I want to cover as much ground as possible. You're the boss, you're the de facto CEO. That's what we understand in business parlance as what the executive chairman is, okay? So that's number one. In 10 seconds or less, can you just tell me what a notice to weigh on landing is? And I'll defer to yourself, Mr. Hayes, on that one. What is a notice to weigh on landing?
And I'll defer to my colleague, but all I was going to say, Deputy, in relation to the relationship part that you raised earlier on, I would actually call it a healthy friction between a regulator and a regulated industry.
Thank you.
Healthy friction.
Okay, thank you.
So, under a 61-1 regime, so under a control plan, the normal expectation of a fisherman rocky up to a pier in Ireland is that they're going to send their fish to a permitted establishment. That's a reasonable expectation. In the case of pelagic fish, we're obliged to weigh 5% in a certain way before transport. So it's a completely different paradigm for them, for that landing. So the notice to weigh says your landing has been selected as one of that 5%. And even though you expect it to be weighing up the road, you're now weighing right here, right now, today.
Okay.
And the important part of it, Deputy, the important part of that is that the weight before transport is the weight that counts for the declarations that Deputy Pringleton referred to earlier on.
Okay, thank you. So, Mr. Hayes, you made reference to a meeting that took place on the 4th of February earlier. And could I ask if the issue of notices to weigh on landing were discussed at that meeting? And if they were discussed, was there an agreement reached in respect of the terms of the notices to weigh on landing? Was that agreed at that meeting on the 4th of February? And again, that's a yes or no. I don't need a long context.
Well, it's not a yes or a no, Deputy. Sorry, no. But at that meeting, right, a number of things were discussed, right?
Okay.
And following that meeting, the industry were given 3 options to weigh on landing in Killybegs. One of them included use of the pier side weighing device for the controlled landing, right?
Okay.
But, Deputy, and this is why it's not an yes or a no answer, at that same meeting, what was also discussed was the ownership model of the pier side weighing device, and the 3 options were given on the basis that the ownership model would be addressed going forward. What happened after that was the ownership model wasn't addressed going forward. We found ourselves in a position where we were non-compliant with the control plan, and on the 6th of March we withdrew the option to use the pier side weighing machine for the 5% of weighing.
So is it possible within reason for you to characterise how the industry would have perceived the outcome of that meeting on the 4th of February? In other words, could they have perceived that there was some degree of agreement in respect of the issue of the notices to weigh on landing? Is that possible?
So Deputy, I referred to this in my opening statement, and it's regrettable that there was confusion, but from my information of the meeting of the 4th of February, which I didn't attend, it was made clear to the industry that compliance with the control plan meant that the 5% had to be done on a non-industry owned, non-industry operated weighing device. The options were given on the basis that the ownership model was going to change to be compliant with the control plan. That didn't happen in the event.
So what was the process then by which you withdrew the notices to weigh and landing? That you said, I think you did it on, did you say you did it on the 6th of March? Or did I?
You mean the third option,
Yeah.
Deputy, yeah?
Yeah.
Yeah, so I think I outlined this for Deputy McLaughlin earlier on, that there was a subsequent meeting on the 11th of February where a lease proposal was put forward by the sector, and then the owners of the machine attended a meeting on the 21st of February and said, this isn't going to happen, there isn't going to be a lease agreement. So in other words, the transfer model wasn't going to change at that stage. 21st of February to the 6th of March is us looking at what we could do in those circumstances. 6th of March is withdrawing the option that was not compliant with the control plan.
Okay, so if we all start from the vantage point, as Ms Loughnane has outlined earlier on, that we all value the industry, we all want to see a sustainable industry, that is built into all of our thinking, or any of us who have an interest in the sustainability of the industry, whether you're a processor, a fisher, you know, whatever your vantage point is. I'm trying to now further understand the dynamics in respect of the consultative committee. Because if there was a meeting on the 4th of March, at which you would have attended, as I understand, Mr. Hayes, would there have been an opportunity at that to further discuss the issues around the notice to weigh and landing, right? That's the first question. And forgive me if we're not, I don't have a master's in fisheries policy, okay? So, and I don't mean to be I'm not sounding facetious when I say that. A lot of us are on a steep learning curve. But if there is a consultative committee, you would hope that the culture of that would be such that you would all move together in lockstep, and that the consultative committee would be the mechanism through which you would work through or triage all of these issues. Because the perception I have is that the industry feels as if it's on the back foot now. They feel as if, rightly or wrongly, this is the perception, that they are now being put upon. And what I fail to understand, as a layman in this respect, is why would, and forgive me if it's a stupid question, but I'm not afraid to ask a stupid question, why would the industry have ownership of a device that is the subject of a regulatory process? Why would it be the industry? If you're regulating the industry, why would the industry own the device, the machine? And you've outlined options here for us, you know, the option 1 and the option 2. I'm still trying to fully understand the differences between option 1 and 2, but I've just been doing a little bit of, you know, searching here. And I mean, if I was, just made some notes, is there a danger that you're on option 1, that you're asking an operator to make a false declaration of their landings, as the water will be recorded potentially as fish and not as water? Those were the notes that I was jotting down as I was, and I could be wrong, right? Forgive me if I'm way off the mark. And then on option 2, it seems to me, and again I could be wrong, disavow me of my ignorance again, educate me, that the operator can drain as much water from the fish he chooses or she chooses, but only 2% of the final weight can get recorded as water. Am I understanding it correctly there? Does this not then run contrary to the whole issue of sustainability and preserving the fish? I mean, if only 2% of the final weight can be recorded as water, what I'm trying to understand is, what permutation does that have for the quality of the fish in situ while the fish is going through this process? We're kind of in Kafkaesque territory here, aren't we? That we've reached a point on this lovely island of ours that we're talking about, you know, such options. You know, but I really do want to understand the option 2, particularly because I'm worried, and again, educate me, I'm worried that in that option, the quality of the fish could become severely diminished. And the sustainability question then comes in, the quality question comes in, the value question comes in, that we're all concerned about. You don't have to tell me I'm ignorant if it is an ignorant question, but you can educate me. I'm happy to be educated.
So if I can start with your quite correct statement that we all have an interest in sustainability, but I think you left yourself out of that, Deputy, in that as legislators you have a very big role in sustainability, and what we do in the SFPA as a regulator is your bidding as a legislator. So the legislators have a huge role in relation to sustainability going forward here. If I turn then to the options that are available, Deputy, you're dead right, and there is 2% allowed for water, but in fact what it means is that the water gets weighed as fish, which is not the ideal situation. It's up to the operator to let as much water as he feels he can out of that tank. He dewaters to the extent that he feels possible without affecting the quality of the fish. We would say that that is the least favourable option, but it is an option that's available to the operator if they wish to use it. We would say that option number 1 is a preferable option.
Does that tick the box for you in terms of DGMR?
It is in compliance with the control plan, Deputy.
Okay.
Yeah. So if you turn to option 1, I'm not sure where you're suggesting that there could be a false declaration there, but the system is that
inadvertently making a false declaration, is that a possibility? I'm not saying...
So if I can just go through that option again, Deputy. So the truck is pre-filled with chilled water to let's say half the truck, right?
Yeah.
And it's brought across the weighbridge and a weight is recorded, right?
Yeah.
Then that truck backs up to the pier side device and the fish are added to the tanker. And then the tanker drives off again to the weighbridge and is weighed again. One weight is deducted from the other, giving a very accurate weight for the weight of fish.
But are you not now putting an onus on the vessel to have within the vessel ice facilities or storage facilities that are, you know, fit for purpose, so as not to compromise the quality of the fish? Is that not placing an additional burden on the vessel thereafter? Or does this happen so quickly that there is no such compromising the quality of the fish?
So Deputy, this gets a little complicated, but I'll ask my colleague, Dr. O'Mahony, to go through the process of how the tankers would do this.
Do you not think this is all very surreal? Do you not sometimes say to yourself, how do we get to a stage in fisheries policy where we're talking about taking fish off a vessel, putting it into another tank, and then taking that tank and putting it back in to the vessel again?
But no, we're not talking about...
on a human level, is it not a bit surreal?
We're not talking about doing that at all, Deputy, and my colleague will go through it in a minute. But how we got to this point is to ensure the accuracy of the weighing so that we can sustain the stocks going forward, so that your grandchildren and your great-grandchildren...
No, don't patronise me now, sir, please.
And mine as well, Deputy.
You don't need to tell me about my own role here. Mr. O'Mahony, you might just explain to me. We're trying to get it explained for the punter who's watching these proceedings, effectively.
I'm well aware. Yeah. Deputy O'Mahony.
Thanks, Chair.
Mr. O'Mahony might...
Sure, yeah. I'll answer the question about surreality. No, it's not surreal. This is about weighing fish. This is not rocket science. It's about weighing fish. It's about figuring out how much fish will land. It shouldn't be rocket science, Deputy. And the fact that we're having discussion about it is not surreal. This is the backbone of fishery control, of the whole point of giving a quantitative capped amount of fish fishermen can catch needs a backbone to it, and this is about giving that backbone. So there's nothing surreal about that. So essentially I'm not sure where the confusion is in the option 1, but it's very much option 1 because it's our recommended option. We believe it will give a very accurate weight and it will give absolute control over quality. There's no limit to the amount of water they could have. So the big part about option one is that the water is weighed to be, the water is in the tanker before the fish arrive in the tanker. So the tanker has water in it, let's say 10 tonne of water in the tanker. Right? Okay. Tanker then comes to the pierside device, which is both a weighing system, which has been built as a weighing system, followed with active dewatering. By active dewatering, I mean that the fish are tumbled between conveyor belts, and there's a huge fan blowing the water off them. And there's the conveyor belt has a grid in it, so the water can fall down. So essentially, you have fish without water for the few seconds that they are going over the conveyor belt. So then the fish go into the pre-charged tanker.
Pre-charge. Okay.
Yeah.
Okay.
So the only addition to the tanker from its first weighing is fish. That tanker goes over the weigh bridge, you subtract the first weight, so take 2% off that for any residual water, might be in their gills or something like that, and you have an accurate weight of fish. Your question about are we creating an onus? No, because the water from tanker, the second, if the first tanker comes pre-charged, the second tanker can get its water from the water that was with the first tanker's fish. You can divert one way and the other. And the other thing is, are we creating an onus on the vessels? No, the vessels have their RSW, refrigerated seawater. They have their own refrigeration systems. Okay. They have refrigerated seawater. Again, we need to contextualise this. This is 5%.
Yeah.
Yeah. This is the way of unlocking almost 100% weighing up at the factory. That's what we're getting to here.
Appreciate that.
I hope option one's a bit clearer there, Deputy.
Yes, it is.
Since the vote in at all, so I'm asking if we could suspend for 15 minutes. There'll be an hour vote and 15 minutes later again. So.
Okay, are we agreed you want to suspend for 15 minutes, or do you want to continue with the Senator? Okay. Agreed, so we suspend 15 minutes. Okay. Ready? Okay, perfect. We're back in public session. Witnesses, ladies and gentlemen. Deputy Collins, I'll give you the floor.
I asked quite a lot of questions earlier on, Chair. A good bit of time. I need to give me a couple of seconds here. I might.
Do you want me to move to Deputy Prindle?
Yeah, if he has, and I'll come back there in a second.
No problem.
Thanks.
I'm caught in the hop as well, and so, but that's not far away. Look, I just wanted to thank you for your contribution so far and for answering the questions and stuff like that. There are just a couple of follow-up questions I just want to have with it.
10 minutes, okay? Is that okay?
Oh yeah, it won't take even that, I wouldn't think. So just a couple of follow-up questions. I haven't got them all written down, so I can't remember what I was going to say. But just in relation to the landings now in Killybegs are stopped now, are ended because the season's ended up until probably November or whatever. So there's time now to resolve this issue. Between yourselves and the fishing industry and stuff like that there as well. I just wondered, what do you envisage doing over the next number of months to actually resolve the issue in terms of getting this sorted out once and for all, I suppose?
Yeah, so, thanks, Deputy. So landings in Killybegs may have finished, Deputy, but landings continue around the country. So.
Well, pelagic is more finished.
Yeah, sorry, and of course there will be whitefish landings in Killybegs as well. But just to keep in mind, Deputy, that I mean, even throughout this, Killybegs stayed going, and there was still a lot of landings into Killybegs. There is 20,000 landings from large vessels in the country in a year. If you count the smaller vessels, there's 40,000 landings. So, I mean, you still have, landings of whitefish into Greencastle, crab into Rathmullen. You have, if you move down to Deputy Collins's area, you have, potters landing crab and lobster into Skull. All around the coast landings continue. And it's important, and it's something, Deputy, that we didn't touch on in the previous session, is that if this control plan is lost, we're back to the situation that we were in last year, between April and December, where every fish on the quayside has to be weighed.
Yeah, but the Commission have okayed the control plan up to the end of this year.
They have extended it up to the end of this year. And indeed, we have submitted another control plan to them. I guess we could call it the permanent control plan, that we will be engaging with them on over the coming months. We have had one meeting with them so far.
With the Commission, or?
With the Commission, yeah.
Yeah, but what I'm saying is, what is going to be done to resolve it with the fishing industry, with the processors and the boats in Killybegs?
Sure. So as it stands at the moment, Deputy, the control plan that's extended until the end of December is the same. It is the interim control plan, so it contains the exact same conditions as had been the case between the 1st of January and the 30th of April. So that includes weighing on, for the 5% weighing, on a non-industry owned, non-industry operated device such as a weighbridge, as well as all the other conditions that are in it in relation to permitting and cameras, as Deputy McLaughlin was talking about. But I mean, we certainly, as we said earlier as well, are happy to discuss options with the sector. I think somebody called it I forget what they called it, but like it's not. We need to be conscious of our role as a regulator here, Deputy. You know, and I suppose I called it, you know, a healthy friction between us as regulators, and
well,
so it's not something that we can reach a consensus on as such.
It sounds to me that you're, as far as the SFPA are concerned, you've gone as far as you're going to go and you're finished with it now.
I wouldn't say that, Deputy. I mean, I actually acknowledge that one of the suggestions that came forward, or at least one of the suggestions that came forward from the sector in relation to trialling option number 1, as I had outlined, using the pierside weighing device and indeed recording the weights on the pierside weighing device if they wanted to do so, and photographing it, was actually, you know, a very useful option, both from the point of view of the sector and from our point of view, so that we could see exactly what was happening. And I'd certainly be interested in reviving that. But as I also said, we have asked the sector to come forward with any proposals. That was at a meeting in April. I don't recall. 16th of March, my apologies. And I mean, we haven't got any proposals arising from that yet. We're not sure at this stage whether some of the deputies have said there is a willingness to transfer ownership of it. If that's the case, who does it transfer to? Would it be adequate to meet the conditions of the control plan? I mean, there's areas that we can explore, but if there was an easy solution to this, Deputy, I think we'd have found it already.
But so I think, stand at the moment, you're waiting for the industry to get back to you with the response before you do any further meetings on it. That's how things stand at the moment.
Yeah, but Deputy, I'm open to meeting with anybody that wants to meet about this, and I certainly acknowledge the efforts that you have made yourself over the last number of weeks to try and find a solution to this.
That doesn't really matter, but I'm just wondering what's going to happen over the next period as well. So in terms of actually the final control plan that goes, it's gone before the Commission now. So in terms of if there's something that we decide, or that the industry decides, or decide by talking to you or whatever, that is workable, that can make it change this, it's the European Commission that would, or the European structures that would make the decision as to whether that would be acceptable or not, or can accept anything in relation to that.
So I guess this is where I get uncomfortable when people talk about the SFPA negotiating with the industry.
Well, we forget about you negotiating. Say that if we decide something that is feasible to a workable solution, it's the Commission or the European structures that have to decide whether it's acceptable or not.
The competence rests with the Commission,
yes,
Deputy. Yeah.
That's all I want to know.
Yeah. So just to be clear on that, we have put in a draft control plan to the Commission. We have had a meeting to discuss it. As I mentioned in my opening, they're dealing with a new control regulation at the moment. It's in trilogues at the moment, so their resources are tied up in that. But as soon as they can, they're going to sit down with us again and discuss that. I really don't know what the shape of the permanent control plan that comes out of the Commission will be. But I mean,
well, you only just implement what they say, what they tell you, anyway, what they agree. Like,
obviously, we make suggestions and they give us feedback, and we end up with hopefully with a control plan at the end of it. I mean, the alternative is no control plan, which we all know is no alternative at all. So we will certainly work hard to get there, Deputy. But I can't say at this stage what the shape of that control plan would be.
Okay, that's all right.
Thank you, Deputy. Deputy Collins.
Thank you, Chairman. I'll be brief because I asked a lot of questions earlier. It's just you know, like Deputy Pringle said there, you know, there is a little bit of time here to try and resolve this, if there is any hope at all for the future of a lot of the fishermen out there. And there's talks about transfer ownership, and you're waiting for the sector to come back to you maybe about that, and that's a possibility. And you said if there was an easy solution out there, you would have found it. But to me, making fish meal out of fish is not an easy solution, or that's no solution at all. That's a disastrous situation that everybody finds themselves in. And I would plead, and I'd hope that we'd have maybe regular meetings here to see how we can find a solution to this issue over the next few months, and try and see can a plan be put forward, because it's unfortunate when fishermen ring me today, they're talking about tie-up schemes and decommissioning. They want to get out. Now, is that what the department wants, or is that what this government wants, or this country wants? I certainly don't see that, because there's massive potential out there in the water, southwest of my own place where I live, but throughout our country. And it's sad that it's almost at an end as such, and we seem to be continuously destroying this industry for some reason out there. Who or where or how are the rules being driven by the Irish government, by the SFPA, by who, by whatever? Don't seem to be the same rules that are driven throughout Europe, and we find ourselves in this dire situation as such, and a solution needs to be met, like before we face wipeout and maybe serious situations. So look, we'll try from our side here to make sure that every option is afforded to it. I sincerely hope the Minister and the Department will do the same, but I'd ask the SFPA to find a solution and work with the sector to make sure that the solution that suits everybody, that makes sure that it ticks everybody's boxes is worked on. And just, I presume you're not on the decommissioning, but like unfortunate situation, fishermen find themselves asking me the question is, when is the decommissioning starting? And it's sad to think that they can't get a straight answer. It's unfortunate that they're looking for decommissioning as a way out, but unfortunately that's what they're facing. And I presume you have no answers to when the decommissioning is starting in this country.
So Deputy, I presume that your comments are in relation to pelagic landings into Killybegs, because I'd stress again the control plan stays in place for all the other landings. So, I mean, the ridiculous situation that pertained in Union Hall last summer, where fish had to be weighed on the quayside and then brought 500 metres up to a factory up the road, won't happen this year because the control plan stays in place. Like in relation to the dire situation, like I point out that Killybegs continue to operate through this, and a lot of landings, and I can give you statistics on them if you want to, happened in Killybegs throughout the pelagic season this year. In relation to the fish meal issue, you're right to point out that a lot more blue whiting has in this year and last year gone for human consumption. In years past, the bulk of blue whiting used in fact go for fish meal, and it's welcome to see that there's value being added to this fish and that it is going for human consumption rather than for fish meal. But I have to point out again, Deputy, that in relation to the landings of blue whiting, 19 out of 20 vessels that land there, they go straight to the factory for weighing. So when you describe it as a dire situation, I think you've got to take that into account, Deputy. 19 out of 20 of them are weighed in the factory. 1 out of 20 has to be supervised, weighed on the pier side. What the sector have chosen to do in relation to blue whiting, since the requirement came in and the two options were available to them, is they have diverted all the landings that we have declared a controlled landing on into fish meal. So they have taken that option rather than using either of the two options for pier side weighing and putting it into human consumption. Like I would hope that we can avoid that situation going forward, because the more of this fish that goes in for human consumption, obviously the better. Deputy Pringle has referred to the extra value to the crew and to the fishermen themselves if it goes into human consumption. I absolutely concur with that. Much better to see it going for human consumption than going for fish meal. Sorry, in relation to decommissioning, it's a question for the Minister, and obviously it's not something that we'd know in the first place or comment on because of the role of the SFPA.
Thank you. Thank you. Yeah.
Yeah, thanks very much. Thank you very much. So a number of questions. My colleague Deputy Doherty asked about the approach taken for landings in the north, as you know, there isn't a control plan with the north of Ireland or with Britain, and there hasn't been, as you say in your statement, but there have been very substantial numbers of landings that have come through the north over the years. My understanding is since 1983 there have been around 5,000 per annum, certainly thousands per annum that have come through the north. So the question I would ask is, you've been in existence since 2006, the SFPA. How many permits have you, how many licence for weighing permits or permits for weighing have you removed in all that time for landings that came through the north?
Deputy, there's nothing wrong with landings coming through the north.
Well, that's not the question I asked. I asked how many times have you withdrawn the permit from an operator for landings that came through the north? How many times in all those years? You've been in existence since since 2006.
So, Deputy, there's nothing wrong with landings coming through the north. We're quite happy to see landings coming through the north. What has to happen with a landing that comes through the north is it gets on landing in Northern Ireland, and then that is the weight that has to be used for everything from there forward, including sales notes, transport documentation, etc. So there's nothing wrong, as I say, with those landings happening.
But do you not find it difficult for our committee to comprehend that for all of those years, so they've been carrying out landings through the north, thousands every year from '83. You've been in existence as a regulator since 2006, and it's only now, in this high-profile scenario, where processors have challenged you, only now that you're actually removing permits, or has it happened before? If it's happened before, it's fine. Just let me know.
I don't want to stray into operational matters here, but like we do have to look at all landings, whether that is in the future or in the past. And obviously data would be available to us in the past. And I'll leave it at that, Deputy.
Yeah, no, it's just that it's very peculiar that I'm sure you'll accept, this committee would find it peculiar that it's only now that a weighing permit has been removed after thousands of landings happen every year, and as Deputy Doherty confirmed, it's the department in the north that's responsible for doing that. Anyway, I'll leave it at that. The next question then is in terms of the issue of the...
Yeah, I'm not sure if it helps. I'm sure you'll cut me off if it doesn't help, Deputy. But I can speak to the reciprocal of your question. That I can tell you that since the coming into effect of the control plan in 2012, we've had several instances the other way around, where we've had operators landing to a port in Ireland. Dunmore East comes to mind, Killybegs comes to mind, where they were going to a northern processing facility, and were not minded to be weighing in Ireland. We made it very clear they need to weigh in Ireland, and we enforced the weighing in Ireland upon those landings, because there was no for the very same reason there was no common control programme in place. So it's a reciprocal answer to your question, Deputy.
You use terminology, I understand, in your correspondence with the companies outside of Ireland. Do you find that regrettable, that you describe Derry as outside of Ireland?
Deputy, we're not going to talk about those particular cases.
Yeah. But in general, would it be regrettable to say that Derry is outside of Ireland? I am sticking to it's the weighing issue. It's completely connected to it.
Okay.
Is it regrettable that an agency...
outside jurisdiction of where we're going, fair South Deputy.
How is it? It's completely connected to it. It's connected directly to the weighing controversy in Killybegs, that question.
I would think that's, as a guest...
It's absolutely connected to it. It's totally connected to it.
I actually disagree. Could you please ask your next
Okay,
question?
I'll have to accept your forbearance in that, but it wasn't answered. The question wasn't answered anyway. In terms of the weighing system on the pier at Killybegs, and I've said that, and all the public representatives understand that the industry do and are very eager to hand it over to non-industry control to address the concerns. Could you define what non-industry is? What is non-industry control?
What I've said
What does it look like?
What I've said in relation to that, Deputy, is that we have asked the industry to bring forward their submission in relation to how they would see this operating, and that we will look at that then.
Okay, but could you define what non-industry control is? Is it a charity? Is it the Department of the Marine? What is non-industry control?
But Deputy, this machine is in the ownership of the sector. It's up to them to bring forward a proposal in relation to
but could you define what non-industry is? I mean, I'm going to say that I think that non-industry is an independent, I don't know, community organisation in Killybegs or the Department of the Marine. Would that be agreeable with you?
Well, Deputy, what I want to make clear is, and it wasn't you, but I think I did make it clear with one of the other deputies, that this isn't just as simple as transferring the ownership. There is more to this as well. So I don't want deputies going away from this meeting thinking that the simple solution to this is to transfer the ownership. What we've said is that we look at it in the round when the proposal comes forward from the sector.
But you can't define what non-industry is.
I'll look at the proposal when it comes forward from the sector.
But the European Commission have said to you, resulting from your negotiations with them, which is peculiar, but they have said to you that they want it to be non-industry. What is non-industry?
Well, what they've said in the control plan is non-industry owned, non-industry operated weighing device such as a weighbridge. So we have to be satisfied, Deputy, and I think we're sort of splitting hairs where we are here at the moment, but we have to be satisfied as a regulator that we can use whatever device we can, whatever device we feel is appropriate, to conduct our controlled landings, the 5% that we have to do it.
Okay.
We have to be cognizant that the Commission also have to agree that, because there's not much point in us reaching a benchmark of 5% and the Commission saying, actually, we don't think you reached any.
It just strikes me as a weighing system that a High Court judge has said should be brought into being. I don't think you can get a better system than that. So the issue is then put that in the control of somebody who's not the industry. So I just, in my simple brain, it seems quite straightforward to resolve if you had the will to resolve it. And I hope you have the will to resolve it, because we shouldn't be here today. I think it's terrible that we all have to be here today. Now, the final thing is risk analysis. I want to just probe through in terms of your what's available to you. Electronic fishing logbooks. I said earlier on that the European Commission's view is Ireland is the most compliant in terms of regulations in Europe, which would make you the strongest regulator. So you have electronic fishing logbooks, VMS data, dipping of RSW tanks, overt surveillance of vessels landing, overt surveillance of factor weighing. All of this is required for you to fulfil. Covert surveillance. You can do joint operations with the Garda and Revenue. Phone surveillance, I understand you can do that as part of joint operations if that was required. So you have really considerable. Can you confirm that you have all of those powers that I've just outlined? Either solely or jointly with the Garda or Revenue?
The powers available to us are the powers that this Oireachtas has given us. They're set out in Section 17, Section 18 of the Act. They include some of the items you mentioned, but not all of the items you mentioned, no, Deputy.
Well, would you, I'm not asking you if you have, but if you felt it was necessary, can you do joint operations with the Garda and Revenue in terms of phone surveillance? Can you carry out covert surveillance? Is that in your legal, now that would be jointly with Garda Síochána and Revenue, not solely on your own?
I'm not aware of any legal provisions for that, Deputy.
So you're saying that you would never have used covert surveillance, phone tapping in cooperation with the
broad
Garda?
phrase of covert surveillance, then go on to narrow phrase of phone tapping.
Where's this part of the actual?
This is in relation to the SFPA's responsibilities and their powers. And what I'm trying to demonstrate in my questions is they have hugely significant powers. They are the.
Do we ask them the powers they have, so?
Sorry?
Would we ask them what powers you have?
Yeah, I've asked them to spell out. I've said that I understand you have the ability to carry out even covert. You can obviously have all sorts of overt surveillance, which I've rhymed off, which I think you would agree with. But you also could use covert. So you have really, really huge powers.
No, sorry, Deputy. The powers we have are enshrined in the legislation you give us.
Yeah.
And the bulk of that is Section 17 and Section 18 of Sea-Fisheries Maritime Jurisdiction Act. There is no mention whatsoever to my knowledge of
So you don't have the power to use covert jointly with other agencies, no?
well, covert is a much broader term now than phone tapping, in fairness.
Yeah.
Yeah, so we would look at VMS data. So the fisherman wouldn't be where we'd be looking at his VMS data, for instance. So that, I mean, if that fits your criteria of covert, I'm not sure.
So your answer is no. You have never availed of.
No, Deputy, the answer is that the powers are set out in the legislation that this House has put in place.
So, and I'm asking, do those powers include joint covert surveillance within Garda Síochána and the revenue? I mean, if it's in law, it's not like surely you can tell me if it does or not.
So we conduct joint operations with Gardaí, which involve us standing on the side of a road, stopping trucks with Gardaí, and if there might be revenue might be present, probably more social protection really, if there's a truck full of people who might be perhaps at risk of conducting revenue fraud. They would look at them. If there's a truck full of fish, then we would look at the fish. So that's a joint operation with the Gardaí and other government departments.
So to conclude, I will very quickly. So you have really significant powers. You've attained oversight of the factories with CCTV at an unprecedented level that doesn't exist anywhere in Europe. You're seen as the strongest regulator in Europe. And we can't get some solution to what's going on in Killybegs that's acceptable. That you guys have the highest reputation in Europe as regulators. You're seen as the strongest regulators in terms of the industry, and we can't get Europe to. We can't. I suppose the concluding comment I make, and I appreciate your forbearance, is let's sort this out, folks. You have to do your job. You have to make sure there's not illegal fishing. You have an array of serious powers. You have achieved a serious level of oversight, unprecedented in Europe. Surely we can sort this out. Surely we can get to a point where we allow the industry to survive while you do your job, which is an important job. That's all I'm asking.
I'm glad you're acknowledging the job we do, Deputy, but we all have to keep in mind that that's a job as a regulator, and there are parameters that we have to work within. We're willing to discuss with anybody how we can advance in relation to that, keeping in mind that we have legislation from you as the Irish legislator. We have EU regulation that you insist that we implement, and we have to keep those functions, those issues in mind when we're arriving at a regulatory regime that will underpin the sustainability, the authenticity, and and prevent food fraud, to be quite straight about it, within the Irish fishing sector, seafood sector, and food sector generally.
Okay.
Thank you, Deputy. I've just a few minor questions that you might be able to respond. You mentioned in your submission, in your statements previously, that the control plan, the permanent control plan, is being worked on at the moment, and you're after initial, if not in deep negotiations with the Commission on it. Could you elaborate on the timelines and when you propose to have this actual control plan brought forward? What changes are you looking compared to the actual control plan that's there at the moment? So we have an indication of where this control plan is going to come in and what will be the new regime regarding that control plan.
So the interim control plan, Senator, as we said earlier, has been extended up until the 31st of December. While that gives us a window to enter discussions with the Commission, we're very conscious of not wanting to get right up to the end of that window and perhaps be stuck in a situation that we've no control plan in place again for a period. So we want to move straight from one into another. So we would hope to have that control plan in place, and I'm only guessing now, our Senator, but in the third quarter, fourth quarter of this year, but not right up against the 31st of December, which is essentially what happened last year. The plan was agreed right at the death of the year, came into being on the 1st of January. It presented the SFPA with an enormous problem of permitting those factories that Deputy McLaughlin is talking about, and a whole pile of work to do. In relation to the contents of it, Senator, I'd prefer to wait till we're at a more advanced stage with the Commission, to be fair to them. I don't think
but at some stage you'll come back to the committee with details of that plan.
I'm happy to do that, Senator. I'm happy to do it when we reach agreement with the Commission, if that's what the committee would like. But to be fair to the Commission, I don't think it would be appropriate to have that negotiation in a public forum.
I appreciate that. Can you talk me through option 1 in your actual presentation? Can you talk me through, obviously there's an issue that I just don't get regarding why option 1 wasn't picked up.
Sure, Senator, yeah.
Can you just explain to the layperson exactly where option 1 is, why it wasn't picked up and why it wasn't actually enacted?
I can certainly have a go off the first part of that, Deputy, but like you, I'm puzzled about why it wasn't picked up and why it wasn't acted upon, right? But I guess just the bigger picture here, Senator, is I was outlining earlier that we have a number of fish stocks off our coast. I guess we're lucky to be the richest fishing grounds in Europe. And those stocks are assessed scientifically to establish what the outtake from those stocks can be. That sets a limit. It feeds into the quota management, which is the business of the Minister. Quotas are distributed and vessels go out to fish, and that's where the SFPA come into this. So vessels go out, they fish those stocks, they land, and we meet them at the quayside. 19 out of 20 of them will go to the factories and they'll weigh what they have in their factories, and I'm talking about bulk pelagic fisheries here now, mackerel, horse mackerel, herring and blue whiting, thank you. 19 out of 20 will go straight to the factory because we have a control plan in place that allows for weighing in the factory. On the basis of those 19 landings going to the factory, 1 out of 20 has to be weighed under our supervision at the pier side. So option number 1 allows for, and these fish are transported in bulk tanks containing refrigerated seawater that's chilled down to keep the quality of the fish preserved. So the vessel pulls up to the quayside and those fish get pumped into the pier side device, which is, for all intents and purposes, I'm sure Deputy McLaughlin has seen it, a hopper and a conveyor belt system that carries the fish up the conveyor. There is as Deputy McLaughlin again has pointed out, there is a facility to weigh on it, a continuous belt weigher. But in option number 1, we don't use that weighing facility. We just use the conveyor portion of it to convey the fish into a tanker that's waiting under this machine that has been pre-charged with water, refrigerated water, and has been weighed on a weigh bridge. So we have a weight for the tanker and the water. The fish is added, and the tanker with the water and the fish goes back over the weigh bridge again. It's weighed again. One weight is subtracted from the other to give a very accurate weight for the fish. The fish then goes to the factory for processing.
And does it affect the quality?
Our view would be that it has minimal, if any, effect on the quality, Senator. But as I was saying to Deputy Pringle earlier, the proposal that the industry had in relation to trialling this would certainly be very interesting from our point of view and very interesting from their point of view. And I'm at a loss as to why, when the sector agreed to do that trial, that it never actually happened afterwards.
And the other option was weighing on the actual pier itself, wasn't it?
The other option is that the fish don't go into the pier side device at all. They get pumped directly from the vessel into a waiting tanker that's empty, but we know the weight of the tanker that has been.
And that does have an impact on quality.
That probably wouldn't have an impact on quality either. Now, as my colleague outlined, some fish are more robust than others in these circumstances. But water and fish is pumped into the tanker goes to the weigh bridge. The operator removes as much water as he or she wants to, while keeping in mind preserving the quality of the fish. Then it's weighed on the weigh bridge, and the weight of everything that's in the tank is recorded as fish, and therein is the issue.
Option 1 was the better option of all options.
Yes, Deputy, because the issue with option 2 is it's fish and water you're weighing together. So no matter how much water you let off, and keeping in mind that you have to preserve the quality, you will still be weighing fish and water.
And in the control plan, I don't want to go into specifics, your permanent control plan, there will be some level of thought put into how you're going to deal with this issue. Would that not be fair?
That is fair, Deputy. I can't say that we'll crack this nut, but certainly we have proposals in the draft control plan.
And was there ever issues, was there ever thought that the department should have an input into how this should be weighed? In other words, the actual weighing, which was industry owned at some stage, that the department should have a stake in it. Was there ever talks of that?
So just to be clear on that one, what the regulation says, Senator, is that the weighing has to be carried out by the operator. So our role is to supervise that weighing, but that weighing is the responsibility of the operator.
I appreciate that, but
No, the department does have a role in what we do at the moment because they own the weigh bridge that we use there, you know. But other than that, there is really no role for them in that in the 19 out of 20 cases, they're weighed in the factory on a continuous belt. In any case, the 1 out of 20 has to be weighed under our supervision, and the options available under the current control plan are option 1 and 2 as outlined in my opening statement.
You use a phrase in one of your contributions that there was healthy friction between yourself and the fishing industry. What was the phrase again? It was you had some.
I would describe it as healthy friction, and maybe I'd be better letting my colleague, the Director of Transformation, deal with this. But I think you'll always have that situation where you have a regulator with a role here, and you have the industry that you're regulating.
And what would you classify your relationship to the department? Is it healthy friction as well?
We have a working relationship with the department, I'd say, Senator. I mean, the department and the minister depend on us for figures in relation to landings, like we're talking about here, for example, for many statistics in relation to fisheries. So we have a working relationship. I wouldn't say that there is friction in that working relationship.
And you might, and forgive my lack of understanding, explain to me your board or your actual setup. Is that you don't physically have a board, do you, or how do you actually constitute yourselves?
No, so the Act sets out the structure. So the structure is an authority of at least 1, at most 3, that are appointed by the minister, and from within that authority, 1 member is appointed as chair of the authority.
And at the moment there is only, how many appointed?
Just me.
Okay. And what was the membership of the last previous years? Was it more than 1?
It was at the full 3. There is a process underway at the moment, Senator, to recruit the 2 vacancies that are there, and I would hope that happens as soon as possible. But I would certainly expect that in the coming months that we'll be back up to full complement.
Okay. Right.
Do you want my colleague
Indeed, give me. Yes, indeed.
Yeah, so in terms of the relationship with the consultative committee, and we have certainly described it as you know, one where there's a healthy friction. That's not to say that we don't work collaboratively where possible. At the end of the day, we're the regulator, and there's an onus on us to regulate and to implement the laws of this House. But we have, you know, there is cooperation in relation to, we have cooperated in relation to the development of a code of conduct for vessel owners. The committee we would have worked, I would have actively engaged with the committee in relation to the development of KPIs. And there's some really good expertise on that committee. There was we would have worked with the committee to provide extensive information, and this predates my time to a large extent in relation to Brexit. And it's not just confined, I suppose it is important to state that consultation happens in many forms, and while it is, the committee is one vehicle for consultation, Section 48 of the Act would state that we can work with the consultative committee or by other means. And I think it's important to acknowledge the role played by people right across the organisation, whether that be Sea-Fisheries Protection Officers engaging with fishermen on the pier, but it's also things like canvassing the opinions and the expertise of industry members in relation to the development of new technology. And we value this input, and that allows us to be more effective and to be more efficient in terms of carrying out our mandate, and ultimately securing the sustainability of the industry for future generations.
On my final point, regarding your role as the regulator, you take other regulators in other streams. We'll say the digital regulator, Helen Dixon. She had a very competitive role with maybe the Department of Social Welfare regarding issues. Have you ever had remit regarding taking on the Department of Agriculture and Marine regarding issues in your role as regulator? Or is your role as regulator really about regulating the actual activities of the fishing industry rather than the department and how the department activate or work within their remit?
Absolutely, it's about regulating the fishing industry, Senator. There is provision in the Act where we can make suggestions on policy matters to the Minister, and that obviously is the Act provided by these houses. But our job is regulating the fishing sector and the seafood sector. And I think in my opening statement I outlined all the roles that we have. But they face towards the sector as a regulator.
Okay. Thank you very much, these witnesses, and thank you for your contribution here today. It's been a very long session. And thank you, members, and obviously external members joining us as well for their contribution. The next meeting of the committee will be held on Wednesday, the 25th of May at 5:30. Committee hearings will hear from officials from the Department of Rural and Community Affairs and also Bord na Gan. First session will be the Dog Breeding Act established in 2010 and Dog Control Act 1986. Second session will be on the priorities regarding Bord na Gan. Unless there's any other business, this meeting will stand adjourned. Agreed? Agreed.